ಏನಿದೆ ಹಿಂಗಿಟ್ಟಿದ್ದಾರೆ? ಏನಪ್ಪ ಇದು? ಯಾರು ಲಾಯರ್ಗಳು ಕಾಣಿಸಲ್ಲ, ಏನಿದೆ? ಅವ್ರು ನೋಡಿ ಜಾಸ್ತಿ ಬಿಟ್ರೆ ಅವ್ರ ಟೇಬಲ್ ಮೇಲೆ ಹತ್ತು ಬಿಡ್ತಾರೆ ಇವಾಗ. ನೀವು ಮಾಡಿದೀರಾ ಅಲ್ಲಿ, ಇನ್ನೆಲ್ಲಿದೆ? ಏನ್ ಮಾಡ್ತೀರಾ? ಹಾ ಹೇಳಿ, ಏನಪ್ಪ?
Education, Your Lordship, education matter.
Monday.
Adjournments.
ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಅದು ಪೆಟಿಷನ್? ಡಿಸ್ಪೋಸ್ ಇದ್ರೆ ನೀವು ಅಪೀಲ್ ಹಾಕ್ಬೇಕು. ರೀಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಏನಕ್ಕೆ ಇವಾಗ ಫೈಲ್ ಮಾಡಿದೀರಾ? ರೀಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದೀರಾ? ಆಯ್ತು ತಗೊಳ್ಳಿ, ಅದು ಟ್ಯೂಸ್ಡೇ ನೋಡೋಣ ಅದು ಬಂದ್ಮೇಲೆ.
Adjournments.
ಯಾವ್ದು ಕರೀರಿ? ಸೆಲ್ ನಂಬರ್?
Page number 10, serial number 75 to 77. Page number 11, serial number 78 to 87.
85. At the request of counsel for the petitioner, released on 8th Rajana, released on 12th March. Interim order earlier granted is extended till next day.
Serial number 49 ಮೇಡಮ್.
ಇವಾಗ ಯಾವ್ದು ಕರೆದಿದೆ ಅದು ಮಾತ್ರ ಹೇಳಿ. 49 ಹಿಂದೆ ಹೋಗು.
Serial number 79, my lord.
Yes.
Petitioner. Updated 2 weeks time, my lord.
At the request of counsel for the petitioner, released on 13th March.
Interim order.
Interim order earlier granted. It's made clear that no further adjournment would be granted. ಎರಡರಲ್ಲೂ ಅದೇ ಬರ್ಕೊಳ್ಳಿ. No further adjournment would be granted if arguments are not advanced on that date. Petition would be liable to be dismissed for non-prosecution. Yes. For what?
We have got instruction that the matter has been settled.
Okay. Have you informed the respondent? Settled ante ಹೇಳೋದೇ ಬೇಡ ಅಂತ. 78 learned counsel for the petitioner submit that is learned counsel for the petitioner seeks for and is granted a week's time to obtain instruction as to whether the above petition would survive for consideration. Released on 13th March. 39 ಕರ್ದಿಲ್ಲ, ಯಾವ್ದು ಕರ್ದಿದೆ ಅದು ಮಾತ್ರ ಹೇಳಿ.
Page number 12, serial number 88 to 93.
89, my lordship.
89.
2 weeks time may be granted because the petitioner has been passed away, my lordship. We are going to file next.
Petitioner is passed away.
Yes, my lordship.
89 learned counsel for the petitioner submit that the petitioner has expired.
Yes, my lordship.
He seeks for and is granted 2 weeks time
Yes, my lordship.
to ascertain if the above petition would survive for consideration. And if so, whether the legal representatives of the petitioner are required to, yeah, accused are.
For in one case accused, in another case, it is connected matter in that petitioner, my lordship.
ಬೇರೆ ಹೆಸರಿದೆ.
In the, in second matter, my lordship.
And if it
That-
survives
there
for
are-
consideration to bring on record the legal representative, released on 19th March.
Much of.
Page number 13, serial number 94 to 100.
Serial number 47, my lords. I'll withdraw the petition. 47, 47.
One-
First list.
File a memo.
I'll file a memo by the end of the day. Before the
It
registration.
now.
Please.
File it now.
Please.
Petitioner is before this court seeking for the following release. Memo dated today's date has been filed, signed by the counsel for the petitioner, which reads as an accepting the said memo and submission of counsel for the petitioner. Petition is dismissed as withdrawn.
Obliged.
Serial number 49.
Hmm.
Matter is settled between the parties.
Hmm.
2 weeks time may be.
49 learned counsel for the petitioner submit that the dispute between the 498A has been settled between the husband and wife. And as such, given 2 weeks time, he seeks for 2 weeks time to keep the parties present for disposal of the above matter as settled, released on 19th March.
Number 25. Withdrawing.
25. Petitioner is before this court seeking for the following leave. A memo dated 1/3/24 has been filed, signed by the counsel for the petitioner, which reads as under accepting said memo on counsel for the submission of counsel for the petitioner, petition is dismissed as not pressed. 30? 37. Petitioner is before this court. The memo dated 1/3. Kindly be dismissed andre. Dismissed as withdrawn and bariri. Dismissed andre merit ಮೇಲೆ ಆಗಿದೆ. Dismissed as withdrawn and bari. ಈ page 33 to 42 ಅಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ?
63, my lord.
39.
My lord, my lord, serial number 34.
ಹಾ ಏನಕ್ಕೆ ಟೈಮ್ ಬೇಕು ನಿಮ್ಗೆ? For what?
Purpose of whether they have returned the cash from the credit card.
So settlement ಆಗಿದೆಯಾ ಅಂತನಾ?
Then I-
39. Learned counsel for the petitioner seeks point is granted 3 days time to obtain a week's time to obtain instruction and make a submission as to whether the above petition survives for consideration or not. Released on 19th, on 12th March. Page ಕರೆದ್ಬಿಡಿ. Page 6.
Page number 6, serial number 33 to 42.
Malad, seal number 32, Malad.
32.
Seriously. I
Yes.
appear for the, Malad, I undertake to file wakalat for the respondent. The Lund senior advocate's name is on record. I undertake to file NOC wakalat, Malad. And a week's time may be given, Malad.
ಮೇಲ್ ಮುಸ್ಬಾ ಹಾಕ್ಬೇಕಾ? Whose name has to be shown?
Adnav Bagladi.
Shri Arnav Bagalwadi submits that he has entered appearance for respondent.
Please.
Registry is directed to print his name as such and delete the name of Shri S.J. Chowta. Have you informed the petitioner?
Kindly be extended, please.
Please,
The interim order.
He seeks for and is granted
1
2
week's
weeks time
Two
to get ready and address his arguments. Relist on 19th March. Interim order earlier granted is extended till next day.
My lord, serial number 34, my lord.
34.
Yes, my lord.
Yes.
Praise 1 week time. Senior's name is reflecting. We'll file wakalat in a week's time, my lord.
You will file or you have filed?
We will file.
Who will file?
Rajat, Advocate Rajat.
Shri so-and-so submit that he would be appearing for the petitioner. Filing wakalatnama for the petitioner. If needful is done, registry is direct print his name as such and delete the name of Shri Chandramouli HS as that appearing for the petitioner.
Please,
Learned
my
AGA accepts notice for respond number 2 also. HCGP accepts notice for respond number 2 also. At the request of counsel for the petitioner, relist on 20th March.
Grateful, my lord.
Lord, serial number
43. ನೀವ್ ಯಾರಿಗೆ? Respond inform ಮಾಡಿದೀರಾ? 43. At the request of counsel for the petitioner, relist on 13th March.
Lord,
Interim order.
Lord, serial number
ಯಾವ್ದು ಈ ಪೇಜ್ ಅಲ್ಲಿ 43 to 52 ಕರೆದಿರೋದು? ಅದು ಮಾತ್ರ ಹೇಳಿ. ಡೋಂಟ್. ಹಾ. ಹ್ಮ್. ಏನಕ್ಕೆ? So 2 weeks ಬೇಕು. ನಿಮ್ ಸೀನಿಯರ್ ಕರೆದ್ರೆ ಅವ್ರು ಏನ್ ಆರಾಮಾಗಿರ್ತಾರೆ. Don't make false submission. 45. The request of inform ಮಾಡಿ respond ಇಲ್ಲ. The request of counsel for the petitioner relist on 20th March. It is made clear that no further adjournment would be granted if arguments are not advanced. Yes. Hmm. Hmm. So whose name has to be shown? The wakalatnama is there. 46. Registry is directed to print the name of Shri Suraj Sampath as that appearing for the petitioner and delete name of Tammaya HN. Have you informed respondent? Will illa. We are not adjourning once it reaches.
Number 48.
Hmm.
48.
At the request, 48, at the request of counsel for the petitioner, relist on 12th March. No further adjournment.
Page number 8, serial number 53 to 64.
56. I am for petitioner.
Hmm.
1 week time. 56.
Have you informed the respondent?
Yes, sir.
56 at the request of counsel for the petitioner released on 19th March.
But 63, my lord. File memo for withdrawal and not
Hmm?
63, my lord.
63.
Yes, my lord.
Petitioner is before this court seeking for the following relief.
Serial number 61.
A memo dated 1/3/2024 has been filed, signed by the counsel for the petitioner, which reads as under. Accepting the said memo and submission made by the counsel for the petitioner, petition is dismissed as not pressed.
Serial number 61, my lord. I
Hmm.
am for the petitioner. The parties have arrived at a settlement, my lord. We have withdrawn all the civil matters. This matter and other two criminal petitions are pending, my lord. 2 weeks time may be granted. We will file joint memo also. Joint.
And keep the parties present.
Please.
498A, na?
Not one. It is other 447 and 427 and 506.
Anyway, you have to keep the parties present.
Please, my lord.
61, learned counsel for the petitioner submit that the dispute with, civil dispute between the parties
It's been
had been
settled.
settled. And a joint memo would be filed in the present matter by keeping the parties present.
Please.
Released on 20th March at 2:30 PM,
Please. Interim order by kind.
interim order.
Date 58.
File a memo.
Please, please.
58, petitioner is before this court seeking for the following relief. Memo dated 1/3 has been filed by the counsel for the petition, which reads as under. Accepting said memo and submission of counsel for the petitioner. Petition dismissed as
Withdrawn.
withdrawn,
That's it, sir.
as infructuous stroke withdrawn.
Page number 9, serial number 65 to 72.
67, my lord.
Hmm.
Senior counsel is not feeling well. We have already informed the respondent.
ನೀವು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಗ
Petitioner.
petitioner ಆ ಕಡೆ ಏನು ಕೊಡಿ ಆಯ್ತು 67 at the request of counsel for the petitioner released on 20th March.
Page number 10. Serial number 73 to 77. Order serial number 1. Amrut Chaudhary.
Memo dated 27/2/2024 has been filed by the counsel for the petitioner seeking permission to retire from the matter. Along with the said memo and acknowledgement of the petitioner. MP Raju ಅಂತಿದೆ, MP ನಿರಂಜನ್ ಸಿಗ್ನೇಚರ್ ಇದೆಯಲ್ಲಪ್ಪ. ಮತ್ತೆ there is no affidavit. I am the petitioner ಅಂತ ಹೇಳ್ತೀರಾ. ನೀವು ಎಷ್ಟ್ ಸತಿ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ತೀರಪ್ಪ ನೀವು. ನೋಡಿ ಏನಿದೆ ಅಂತ ಪಾಸ್ ಓವರ್.
Serial number 2. Ajit Agency.
Lords, I appear for the petitioner. Lords, copy has been served, my lords, on the learned counsel appearing for the state.
What is the compliance?
My lords, the petitioner was called upon to file a status report, my lords, as to the yield of the cows which have been handed over to our custody. My lords,
Hmm.
this is a proceeding, my lords, under the 64 Prevention of Cow Slaughter Act,
Hmm.
where, my lords, a total number of 39 bovines were seized,
Hmm.
37 cows and 2 buffaloes. My lords, all milch cows, my lords, which were seized,
Hmm.
and proceedings were initiated, my lords, against 4 individuals. My lords, 39 cattle were being transported in 2 trucks.
When did you file this memo of compliance?
My lords, this was filed, my lords, on the 30th of October 2017 itself.
After that, no milk.
ಅಲ್ಲ ಇದು ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ my lords, of course, I have called upon my lords, the client to furnish the latest report also. That also I'll furnish before your lordship.
You want us to take a compliance report of 2017 on record in 2024, Mr. Shetty?
No, my lords, I have already instructed my lords to give us a contemporaneous report, my lords, that will be done.
So what are you before this court for?
My lords, what happened, my lords, we were the informants. My lords, this is a voluntary organization. The petitioner before your lordship is a voluntary organization. My lords, they were the informants or the complainants before the police. Based on their information, my lords, 2 trucks were seized. wherein, my lords, 39 cattle heads were being transported. And then proceedings were initiated. While proceedings were pending, my lords, an application was filed, my lords, seeking release of those cows, which was meant for slaughter even by the state.
Hmm.
My lords, the revision filed against that order was by us was rejected, my lords, hence the present petition. And by way of interim measure, my lords, this honorable court was pleased to order
Release in your
for
favor.
release of those cows into our custody. They are in our Goshala. Now, my lords, what I have been instructed to submit is, most of them are old cows, unlike what has been represented, my lords, by the accused.
Hmm.
What the accused says, my lords, is that they're all milch cows, my lords, which he had purchased in a fair,
Hmm.
and they were being transported to, my lords, Tamil Nadu.
Hmm.
Contrary to that, my lords, we have now found, we have found that, my lords, if my lords were to imagine in the first set of report, out of 39 bovines, my lords, hardly, my lords, there is a yield of 12 liters per day. That is a report. So that would indicate, my lords, that all the cows were in
So
the evenings of their life.
next report that you are likely to file is all the bovines are dead.
No, they are all alive. So I have got the confirmation.
8 years ago.
ಇನ್ನು ಬದುಕಿದೆ ಸರ್, ಏನು ಆಗಿಲ್ಲ, ಬದುಕಿದಾವೆ. ಇನ್ಫ್ಯಾಕ್ಟ್, my lords,
ಲೈಫ್ ಸ್ಪ್ಯಾನ್ ಎಷ್ಟಪ್ಪ?
16 ವರ್ಷ ಆಗಿದೆ.
8 ವರ್ಷ. You're saying not milk cows.
ಹೌದು.
So there should have been 10 plus
Almost.
years at least.
In the evenings of their lives.
In 8 years andre.
My submission, my lord, that all the cattle are with the Goshala, my lord. They are maintaining. And
Land counsel for the petitioner has filed a compliance report dated 21/9/2017. Allah. What is the date? 21/9/2017.
Please,
The same is taken on record.
lordship may direct me, lords.
He is directed to file fresh compliance report
Very well.
as on date, relist on, as regards the condition of the cows and the milk produced as on date.
Very well.
Relist on 20th March. Learned counsel, learned SCGP is also directed to
information, my
ascertain.
lord, the matter, trial court is closed ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ produce ಮಾಡಿ,
Like,
order copy produce.
charge sheet ಹಾಕಿದ್ದಾರೆ. Now in terms of they'll have to, my lords,
Closed ಅಂತ ಇದ್ದಾರೆ. This is a
Very well.
very old matter.
Very
They
well.
should have got
Their
over.
purpose is served, my lord. They
Their
have-
purpose is served, petition or proceedings would also have probably closed.
I think it's served.
And SCGP 6 fund SCGP is also directed to ascertain the status of the proceedings before the trial court and make his submissions by that date.
Serial number 3. Vijay Narayan,
R6 yarappa.
private party. Police report not at received.
There's no interim order. None appears for the petitioner. Learned SCGP 6 fund is granted 2 weeks time to ascertain the status of the proceedings before the trial court and make its submission. Relist on 20th. If none were to appear for the petitioner on that date of hearing, next date of hearing, petitioner will be allowed to dismiss to non-prosecution.
Serial number 4. Karan Joseph.
I appear for the petitioner.
Yes.
Filed my memo of retirement. Dated 2/6/2023.
My lords, I have already filed my wakalat for the.
You have filed, okay.
Please, my lords. My name is not shown, my lords.
Shri so-and-so submitted, he has already filed wakalatnama for the petitioner. In that we have the memo of retirement filed by Shri Karan Joseph dated 2/6/2023. He is accepted, he is discharged from the matter, registry is direct print the name of so-and-so. As that appearing for the petitioner. Relist on 20th.
Please, my lord.
Karan Joseph's name may kindly be.
You are not hearing what we are dictating.
Please.
Oblige, my lords.
Serial number 5.
Yes, Mr. Sudarshan?
My lord, this matter has been settled. It's a 498A matter between my husband and wife. It has been settled. I will require about 4 weeks time to report settlement, my lord.
Settlement ಆದ್ಮೇಲೆ 4 weeks time ಕೊಡ್ಕೊಡುದು.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರದ್ದೇನೋ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಹೆಸರಿಗೆ ದಾಖಲೆ ಮಾಡಿ ಕೊಡ್ಬೇಕಂತೆ. ದಟ್ ಇಸ್ ಪ್ರೀ ಕಂಡೀಷನ್. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಸಮಯ ಕೇಳ್ತಾ ಇರೋದು.
ನೀವು 4 weeks time ಕೊಟ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಆಗೋಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಆಗುತ್ತೆ ಆಗೋ one part ಆಗಿದೆ.
We'll have it in 2 weeks' time. The KC Sudarshan, learned counsel for the petitioner, submits that the dispute between the husband and wife and the family members have been settled, given 2 weeks' time. The joint memo will be filed and the parties will be kept present. Released on 20th at 2:30 PM
Oblige.
for reporting settlement.
Girish and Patil.
So Girish Patil. ಏನು ಕಾಣಿದೆ ಇದು? None appears for the petitioner today also. And SCGP seeks for and is granted 2 weeks' time to ascertain the status of the matter before the trial court and make a submission. None were to appear for the petitioner on the next date of hearing, dismissal. Released on 20th.
Serial number 7. Another Reddy.
ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಪಿಟಿಷನರ್ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಹೊಸ ಅಡ್ರೆಸ್ ಹುಡುಕಿ ಸರ್ವ್ ಮಾಡಬೇಕು.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
ಸ್ವಾಮಿ 2 weeks ಟೈಮ್.
ಏನಾಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಸ್ಟೇ ಇಲ್ಲ. Dismissal order. The counsel for the petitioner seeks for and is granted 2 weeks' time to furnish the current and proper address of respondent number 2. If needful is done, registry is directed to issue 2 to 6. Registry is directed to issue notice to respondent number 2 to 6, returnable by 24th April.
Serial number 8.
Statement of objections has not been served.
Not served.
Yes.
Who appears for respondent number 2?
Vasan.
NV Vasan.
Where is he? Paso.
Serial number 9. Here Krishnamurthy and connected by
Here for respondent number 2, looks to be connected matter, filed an application seeking treatment. And the complainant have not been arrayed as a party. An application is filed, however, I'll file Vakalat, Vakalat is not filed. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ಬೇಕಲ್ಲ ಅವರಲ್ಲಿ. The connected matter Vakalat has to be filed. And for the petition. 9.
I'll carry out the amendment, my lords, and I'll file the.
We'll implead him again. We'll implead him in this matter also.
Please. One matter he's already impleted.
First pleading applicant and
The connected matter.
Registry is 9. Registry is directed to correct the appearance of Shri P.H. Virupakshaya as that appearing for respondent number 2 instead of impleading applicant for respondent number 2. 9.1. IA number 1 of 2022 has been filed by the de facto complainant seeking to be impleaded in the present matter. Being of the considered opinion that his presence would be necessary, IA 1 of 2022 is allowed, is brought on record as respondent number 2. Counsel for the petitioner to carry out necessary amendment and file amended cause title and print the name of Shri P.H. Virupakshaya as that appearing for respondent number 2. Released on 20th. 22nd.
Serial number 10.
Despite court notice having been issued to the petitioners, none have entered appearance. It appears that the petitioners are not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Serial number 11.
Appearing for the petitioner. Appel memo for withdrawal.
Petitioner is before this court seeking for the following relief. Memo dated. Memo.
Dated 9/1/2022.
It's been filed with reads as under accepting the said memo, the petition is dismissed, reserving liberty to the petitioner to challenge the charge sheet filed.
Serial number 12. Moravian.
My lords, appearing for petition.
R2,
The respondent, there's an objection raised over time.
yes.
I will comply with it. I'm not wrong, I'll understand what some time and use it.
Your friend wants time, he will ask time. You say about your work.
My lord, the petitioners have not submitted the entire charge sheet. They can submit the entire charge sheet, it will be useful.
I'll serve a copy of the entire charge sheet.
And then submitted
Serve
for the
or
registry
file.
for the court also.
I'll file the entire,
They already have, we don't have.
I'll file it, my lord.
ನಿಮ್ಮತ್ರ ಇದಲ್ಲ. Learned counsel for respond number 2 seeks for
I will comply with the office objection.
when?
By Tuesday, on Monday. Before the next date of hearing, will be complied.
We are not going to give you like next date of hearing. By when will you complete it?
Monday,
Don't be so,
by Monday.
we won't use the word because if we use the word, you will not like it.
To comply.
This is a proceeding in court, so you need to be. Learned counsel for respond number 2 seeks for and is granted 3 days time to comply with the office objection raised on a statement of objection. If the said objection is not cleared in 3 days time, the statement of objection will be struck off from the case. Learned counsel for the petitioner seeks for and is granted a week's time to file the entire charge sheet with all annexures. After serving a copy thereof on the respective counsels for the
My
respondents.
lords, may I request for Tuesday, my lords?
So you will serve it by 2 days, within 2 days' time.
I'll
Relist
serve
on 5th.
Obliged.
Obliged.
Admission, serial number 30. Balasubramania has corrected matter.
Counsel for petitioner, my lords, may I kindly seek for short accommodation.
Bill number 30 may be de-linked, Lordship, it may be de-linked and heard separately, Lordship. The matters were linked on one question, whether the FIR is registered by Inspector of Police or DYSP. In all these matters, FIR is registered by DYSP, Lordship, when it was asked while ACB. So these are to be de-linked and heard separately, Lordship, on merit.
Why dealing? There's
Cause of
no,
action is-
only cause of actions are different.
Bare cause of action.
De-link or link, we'll take each one of them and pass orders. Are you ready?
They need to amend the cost item and include the local.
ಅದೇ ಹೇಳಿ. So in this ACB has made a party. 13. Separate order, only same order. In view of the judgment passed by the Honorable Division Bench, all proceedings pending before the Anti-Corruption Bureau have been transferred to the office of the Honorable Lokayukta.
My lords,
In that view of the matter, Honorable Lokayukta is brought on record as respond number 2.
Lordship, 1, 2,
13 ಅಲ್ಲಿ ಯಾರು?
respondent number 1.
Implead ಏನ್ ಬಂತ ಹಾಗಾದ್ರೆ if you are already there on record? You're already there.
Lordship, in the cost item,
ಆಗಿದೆಯಪ್ಪ.
respondent number 1.
In petition,
ಲೋಕಾಯುಕ್ತ ಆಗಿದೆಯಲ್ಲ. 5015 ಅಲ್ಲಿ ಲೋಕಾಯುಕ್ತ ಆರ್ಡರ್ ಆಗಿದೆ.
ಇನ್ನೂ 3 matter.
13.1 ಕೊಟ್ಟು. ಆಗಿದೆಯಾ? ಅದು ಆಗಿದೆ. 13.2.
cost item is amended.
13.1. 13.2, Mr. Ashokpa? ಆಗ್ಬೇಕಾ? 13.2 ಅಲ್ಲಿ. Have been transferred to the Honorable Lokayukta. Hence, Honorable Lokayukta is brought on record as respond number 3. Shri B.V. Patil accepts notice for respond number 3. Registry is direct print his name as such. Counsel for the petitioner to carry out necessary amendment, file amended cost title. 13.3,
Yes, it is amended.
amend ಆಗಿದೆಯಾ?
Yes.
Manmohan P. ಏನಂತಿದೆ?
my lords.
Mohan P.
One more name. Deleted, my lord.
In 13.3 and 13.1.
1, 2, 3.
13.1. Registry is direct, delete the name of Sri Manmohan PN as that appearing for respondent number 1 and print the name of Sri BB Patil as that appearing for respondent number 1. 13.3. Delete Manmohan PN and print the name of Sri BB Patil as that appearing for respondent number 1. Registry is also directed to correct the name of the respondents in the cause list.
13.2.
13.12, we made you respond number 3. I think we don't delete ACB irli, Lokayukta innone party matter. Array of parties changes. All the councils seek for and are granted 2 weeks time to get ready and address their arguments, released on 20th March.
There is an interim order.
Interim order, if granted, is extended till next date.
Serial number 14.
Please.
WHR.
Who has to pay, who has to receive 25,000?
Petitioner was repeatedly kept under spreading laws and by issuing fine levy warrant. The last date, Lordship was pleased to, the Lords pass an order release him subject to he making payment. That payment we had immediately, Lord, the receipt was not produced.
Where is that receipt now?
I filed the receipt along the last.
Yesterday.
And yes, I filed it on 29.
Bandidenama?
Payment, Lord, was made long ago. On 9/3/2023 itself. Payment was
ಅದನ್ನ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾವಲ್ ಅಂತ ಹಾಕಿದೀರಾ ಅದಕ್ಕೆ?
No, no. Lordship one. Sorry, in the presentation.
So in petition will discuss
8 Lordship, operating portion, last para.
These are all proceedings which have been initiated.
And later show cause notice, annexure R2 Lordship.
The final order has been passed on 27/2/2013. Petitioner is before this court seeking for the following reliefs. The petitioner had filed a private complaint in PCR number 692 of 2015 under section 200 of the Code of Criminal Procedure, read with section 499 and 500 of the IPC, alleging that a defamatory article has been published by a respondent in his newspaper called Kemogilu. Initially, notice having been ordered, cognizance having been taken and notice having been ordered, the respondent challenged the same in criminal revision petition number 213 of 2016, wherein the fourth additional district and session judge Mandya, by order date 21/3/2017, allowed the petition set aside the order of cognizance and dismiss the complaint. This challenging the same, the petitioner is before this court. Learned counsel for the petitioner submits that there have been allegations which have been made against the petitioner as regards misappropriation of funds and misuse of the property of the cooperative society, which prima facie is defamatory. And as such, the revision court has not taken this aspect into account. The ingredients of section 499 having been fulfilled, the revision court ought not to have set aside the order of cognizance. Learned counsel for the respondent would however submit that the publication which has been made is in terms of notification issued, in terms of notice, show cause notice issued by the assistant registrar, Cooperative Societies Mandya, dated 25/3/2010, which finally ended up in an order being passed on 27/2/2013. And it is thereafter that the publication was made on 26/9/2013. The reportage made by the newspaper is on the basis of proceedings before a governmental authority, where the governmental authority has taken up action against the petitioner. The said reportage is only amounts to reporting the occurrence of events, and there is no allegation made against the petitioner or such proceedings which have been initiated, and as such reportage cannot be said to be defamatory in nature. Heard so and so various papers. Having gone through the offending article which has been extracted by the revision court in para 13 of its judgment, of its impugned judgment, comparing the same with the show cause notices and the order passed by the Registrar of Cooperative Society, by the officers of the Registrar Cooperative Society from 25/3/2010 to 27/2/2013 at annexure R1 to R4. It is seen that the article which has been published is in terms of the allegations made and the order passed in those proceedings. Hence, I am of the considered opinion that the reportage which has been made of the occurrence of events before the offices of the Registrar of Cooperative Societies is only a coverage of the news and cannot be said to be defamatory. No grounds being made out, the petition stands dismissed.
Much obliged.
Serial number 16, M. Halaswamy.
Yes.
It was not there.
Charge sheet. ಅವ್ರಿಗೂ ಒಂದು ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಫುಲ್ಲು?
Copy not just I'll pass on. Now kindly see the annexure.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ಇಲ್ವಾ? And you have to page number this, Mr. Aluswamy. Page number ಇಲ್ಲ. ಹೆಂಗ್ ರೆಫರ್ ಮಾಡಿದ್ವಿ?
Only witnesses, some statements of the witnesses have been recorded.
ನೀವು ಯಾವ್ದು ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ವಿಟ್ನೆಸ್ ಎಷ್ಟು ವಿಟ್ನೆಸಸ್ ಇದ್ದಾರೆ? ಪೇಜ್ ನಂಬರ್ ಇದೆಯಾ ಇದೆಲ್ಲ ನಿಮ್ಮ ಹತ್ರ?
ಅರ್ಧ ಇದೆ ಫುಲ್ ತುಂಬಾ ಎಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
That is the measure and the statements of witnesses.
Whatever it is, you give them a copy. Whatever you want to rely upon, give them a copy. ಅಷ್ಟೇ.
I'll pass on.
When relying upon it, you can say what it is.
Yes, ma'am.
Before that, you have to give them a copy. ಇದೆಯಾ?
I will pass on my copy. Then after reference.
Pass over one copy ಮಾಡ್ಕೊಡಿ. We'll take it up at 2:30. Pass over.
Serial number 17.
And page numbering ಮಾಡ್ಬಿಡಿ.
Kalyana.
Totally 18 cases have been registered under this accident, my lord. Made an entire list. My lord, what has happened, my lord, the first two, my lord. First two being genuine cases, my lord, we have settled the entire award amount. So that has been disposed of, my lord. The other 3, 4, 7 and 9 is been dismissed as non-prosecution. And 5, 6 and 8, my lord, there is a judgment rendered. So judgment has been passed.
Which is dismissed for non-prosecution?
My lord, 3, 4, 7, 9, my lord. 3, 4, 7, 9.
Non-prosecution.
Non-prosecution dismissal. 5, 6, 8, there is a judgment, my lord, which has been dismissed. So that is also attended.
Is it dismissal?
Yes, my lord.
On what
5, 6,
ground?
On the ground that there are bogus documents which are produced and all these. May I request, my lord, the of page 15 in the Shura. 15 last para 11 in the Shura. The operative portion starts from page 15, my lord, internal page, para 11.
Yes.
Last 4 lines, my lord. A perusal of exhibit R8 discloses that the investigation in respect to the above complaint had been entrusted to COD police, who after going through the investigation have laid down the charge sheet in so and so Bangalore against 23 accused persons alleging commission of offence of punishable under so and so. The present petitioners have been arraigned as accused 7, 8 and 11 respectively. In the said charge sheet, Dr. G.A. Venkateshalu has been arraigned as accused number 14 in the said charge sheet, alleging that he had issued false wound certificates and thereby assisted the claimants in getting compensation from the claims tribunal. The counsel representing these petitioners, namely Sri so and so, has been also arraigned as accused number 18 in the said charge sheet, alleging that he's represented the accused so and so and adduced the evidence in the claim tribunal, knowing fully well that the said documents are false, fabricated, and thereby practiced fraud upon the claim tribunal in getting compensation by the claimant. It is not out of place to mention here that the petitioner in MVC number so and so has produced certain medical bills and prescription as exhibit P6. The petitioner in MVC number so and so has also produced certain medical bills and prescriptions as exhibit P9. The meticulous perusal of the said medical bills discloses that all the said medical bills had been issued from the medical shop by name so and so and General Sol Nelmangla. It is very significant to note that the proprietor of the said medical shop by name so and so has been arraigned as accused number 20 in the said charge sheet, alleging that he had issued false medical bills and accused on. My lord, this is the thing, and then coming to the conclusion, my lord, they dismiss the entire.
Next line is the most important.
1, 2, 3, 4, by colluding with the doctor, lawyer, and the police, and thereby practicing fraud upon the claim. It appears that these petitioners had been referred to the opinion of expert doctor to ascertain the genuineness of these injuries sustained. A perusal of Exhibit P7 discloses that K.S. Manjunath, who was working as the professor of head of department orthopedics at the boring so-and-so, had examined these petitioners and formed opinion that the fractures noticed during examination of petitioners corresponds to the fractures shown in their wound certificate. From the said opinion, it appears that these petitioners sustained injuries probably in altogether different incident. But unless it is shown that the said injuries were caused to the petitioners in the present motor vehicle accident, the jurisdiction of the claim tribunal to award compensation under the provisions of the Motor Vehicles 1988 are not attractive. To prove this aspect of the matter, the
Suffered injuries somewhere else and not here.
Yes.
Baki Allah is because only the complaint has been filed.
That
The
is
positive indication is only as regard the doctor's certificate.
Yes, that is only on the board. And the conclusion, my lord, it has been dismissed with cost.
So
And
these
others,
were-
my lord?
These three were dismissed.
Yes, ma'am. Others 10, 11, 12, 13 to 18, my lord, were allowed. And this was challenged before this court, my lord. It was remanded back in an MFA, my lord. MFA, my lord, after the remand back, my lord, they have not appeared. And that is also been dismissed for non-prosecution. I'm sorry.
So then after remand, it's been dismissed.
Dismissed for non-prosecution, all the matters.
All of them.
All of them.
What about
14?
14? Still number 14?
14 also, my lord, Kemparna, that is also been dismissed as non-prosecution.
They nakilan.
I've not written it there, my lord, but I just got some order sheet online, my lord, which says this is in 7804 in the serial number 16. This order was uploaded, my lord. I've taken a copy of it.
Yes, Mr. Kalyan.
Lord, so far as the proceedings, my lord, which were pending before the MACT are concerned, my lord, the learned amendment, the details furnished by the.
ನೀವು ಉದ್ದ ಇದ್ದೀರಾ ಇದಕ್ಕೆ.
Sorry.
ನಿಮ್ಮ ಇದಕ್ಕೆ ನೀವು adjustment ಮಾಡಿ.
Sorry. My lord, the details furnished by my learned friend, my lord, are so far as the proceedings are concerned, my lord, none of the claim petitions are pending as on today. My lord, some of the claim petitions were initially dismissed by the tribunal, and some of the claim petitions were partly allowed, against which, my lord, appeals were filed before.
Your contention the other day was that after it being allowed, as an afterthought, they have raised this complaint. And they have not raised this issue ever that it is fabricated.
My lord, even in the written statement, their written statement filed before the MACT, this claim was not raised.
But in the evidence, it's
But
been
what
taken
happened was, my lord, it was only based on the charge sheet material filed.
Allapai. See, we don't know what happened in 3, 4, 7 and 3, 4, 6 and 9. But insofar as 5, 7 and 8, they have taken the stand.
My lord.
They have categorically
My lord,
taken the stand.
Nowhere in the written statement, none of the claim petitions, they have taken this stand.
But in the judgment, it is
But
clear.
in the judgment, it is only the reference are made, my lord, whatever the materials available in the charge sheet, only that reference is made.
And
But however,
furthermore, even before it being allowed, they had taken it up in those proceedings, and you are the claim petition filed by you on behalf of your clients has been dismissed.
my lord, only so far as some of the claim petitions, my lord, these petitions, what happened, my lord, all the claim petitions were filed in the year way back in the year 2003, 4, 5, 6. The complaints, my lord, were filed in the year 2005 and 6. My lord, in view of the, my lord, complaint lodged by them, my lord, proceedings were pending for a long time.
Hmm.
And the meanwhile, some of the claim petitions came to be dismissed, came to be partly allowed.
Hmm.
Against which, my lord, appeals were preferred by the KSRTC.
Hmm.
My lord, after filing the charge sheet, the materials were placed before the court. During pendency of the proceedings, my lord, the wound certificates produced by the claimants were referred at the instance of the KSRTC to a medical board.
See,
Medical board opines.
You're on a 482. You cannot argue on, or not can, you can argue. We cannot consider disputed question of fact.
Please, my lord,
You are entitled to argue, but we cannot consider.
my,
Your first argument was an argument which we could have considered
please.
and allowed your petition. But that doesn't survive any longer. Now that these are there, let it go for trial.
My lord, now, my lord, in one of the petition, my lord, one of the case, my lord, accused number 16, who was also an advocate, made an application for discharge. My lord, on merits, he has been discharged.
In this matter, the arguments which are advanced are these.
My lord, that was also.
It is up to them whether they want to challenge the discharge or
My lord,
not. Have you
a
challenged the
similarly
discharge?
placed person, that is not challenged.
That has not been challenged.
That
my
is
lord.
not been
Moreover, my
challenged.
lord,
Haven't you challenged it?
in the discharge application, my lord, the category, the 16 says that it is only in the instance of 17 and 18, I have filed this wakalat.
Oh, he is a junior.
He is a junior, only on the 16. He
My lord,
himself states that.
A17.
Only filed wakalat.
My lord, A17 was junior to A16.
This is all matter for trial.
My lord, that was, my lord, so far as that is concerned, my lord, now they have placed on record, my lord, this. My argument was that, my lord, in view of, my lord, already discharge, my lord, made in so far as the accused number 16 is concerned. My lord, the accused number 17 and 18 are also similarly placed persons. My lord, the allegations against the accused number 16, 17 and 18 are one and the
That
same.
we can't accept now. What do you want to do? You want a finding on something or you want to withdraw? Finding ಆದರೆ ನಿಮ್ಗೆ ಮತ್ತೆ ಕಷ್ಟ ಆಗ್ಬೋದು.
My lord, I seek for, my lord, short accommodation. So that I'll take instructions and make submission.
After arguing for some time, learned counsel, after arguing the matter, heard Shri B.S. Srinivas, learned counsel for the respondents and the counsel for the petitioner. After having argued the matter, Shri Kalyanar, learned counsel for the petitioner, seeks for and is granted a week's time to obtain instruction, make his submission. Relist on 12th March for further hearing at 2:30 p.m.
File everything.
You file it with a memo.
My lord,
The memo, learned counsel for respondent is first according. Learned counsel for respondent has filed a memo enclosing the orders passed by the MACT, some of the orders passed by the MACT and by this court in MFA, Miscellaneous First Appeals. The same are taken on record.
Interim order.
Interim order earlier granted is extended.
Serial number 18. Class rating.
Another connected matter, my lord, 6408/18, my lord. A2 and A3, A1 and A3 filed the 482 petition in the same offense, my lord.
There is another petition. Number another
6408/18.
08 of
18.
18.
6408/18.
Connect the above matter with criminal petition 6408 of 2018 and relist on 13th March. Interim order earlier granted is extended till next.
Watch out.
19. Harish HV.
For the petitioner.
For the second respondent.
Seeks a week. Seeks a week.
Make a submission.
Okay, for the second.
At the request of counsel for the petitioner, relist on 13th March. Interim order idea? Interim order idea, no, extend ಮಾಡಿ. ಅವ್ರು ಯಾರು ಹೇಳಿಲ್ಲ ನಾನು ನೋಡ್ಕೊಂಡು.
Serial number 20. Manjunath G. Kandekar.
Petitioner.
Petition filed
Ready?
by the request for short accommodation. Today, some inconvenience for the argued counsel. I will inform the learned friend.
ಇದೀರಲ್ಲ ನೀವು.
ಅವರೇ ಮಾಡ್ಲಿಕ್ಕೆ.
ಅವ್ರು ಏನಕ್ಕೆ ಬೇಕು? ನೀವು ಇದೀರಿ. ಅವ್ರು ಬಿಡಲ್ಲ, ನೀವೇ ಮಾಡ್ಬೇಕು. ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಹೇಳಿ ನೀವೇ.
Any day, other than March 6th, any day. Other than March 6th.
ನೀವೇ ಮಾಡ್ಬೇಕು.
ಆಯ್ತು, ಖಂಡಿತ.
We'll make note. At the request of Sri Venkatramana, relist on 12th March.
Please.
It's made clear that no adjournment would be granted on that 13th March. Please.
21.
My lord, serial number 21, I appear for the petitioner, my lord.
Yes.
Seeking a short accommodation, my lord, I've informed my learned friend for the respondent.
For the respondent.
My
You will
lord,
be
your-
addressing arguments, madam?
My lord, I'm led by senior counsel in this matter. Today there's some difficulty. Kindly have it on any day next week, my lord. We'll go on with the matter on the next occasion.
Relist on 5th March.
Please,
At the request of
interim order
counsel.
may please be extended.
Yes, interim order.
Grateful.
22. C. Shankar Reddy.
Lord, appear for the petitioner. Lord, I'm
Yes.
seeking adjournment for this reason. Lord.
New adjournment accurate.
Reason is this, my lord.
Hmm.
Wife, my lord, files petition for defamation. And also, my lord, under section 498A, the present proceedings. Lord, different criminal petitions have been filed before this court. Insofar as defamation is concerned, my lord, this honorable court was pleased to dismiss the petition, my lord, for quashing. Matter was taken up before the Honorable Supreme Court. Three-judge bench of the Honorable Supreme Court, my lord, called upon the parties to settle it before the mediation center. That was referred. However, my lord, before the mediation center, my lord, matter could not be settled. Thereafter, it was again listed before the Honorable Supreme Court on, my lord, 5th of February and 26th of February. Supreme Court, my lord, suggested why it is not settled. Then, my lord, we came forward to say, if the request of the other side, my lord, one of the demands made by the other side is that the children's passport, my lord, is withheld by the father who is in UK. Those passports, if it is given back and some arrangements is made, my lord, regarding maintenance, they will.
Who are the children in custody of?
Mother who is in Bangalore.
Then how can you retain the passport?
Exactly.
There are UK citizens, my lord.
UK citizen, ಎಲ್ಲರೂ citizen ಆಗ್ಲಿ. ಯಾರು ಅವ್ರ ಹತ್ರ ಇರ್ಬೇಕು ತಾನೆ ಪಾಸ್ಪೋರ್ಟ್.
ಅದಕ್ಕೆ
ಅಲ್ಲ ಒಂದೇ ಒಂದ್ ನಿಮಿಷ.
ಅದಕ್ಕೆ 5ನೇ ತಾರೀಕು ಫೆಬ್ರವರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಾಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೋರ್ಟ್ ಅಲ್ಲೇನೆ ಪಾಸ್ಪೋರ್ಟ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ
ಪಾಸ್ಪೋರ್ಟ್ ಶುಡ್ ಬಿ ಆನ್ ದ ಪರ್ಸನ್.
ಮೈನರ್ಸ್ ಇರೋದ್ರಿಂದ
ಸೊ ದೇ ವೋಂಟ್ ಬಿ ಏಬಲ್ ಟು ಎವರ್ ಟ್ರಾವೆಲ್. ನೀವು ಪಾಸ್ಪೋರ್ಟ್ ಇಟ್ಕೊಂಡ್ರೆ
ಅದು ಪಾಸ್ಪೋರ್ಟ್ ಕೂಡ ರಿನ್ಯೂ ಆಗ್ಲಿಲ್ಲ.
ನಿಮ್ಮನ್ನ ನೋಡಕ್ಕೂ ಬರಕ್ಕಾಗಲ್ಲ.
ನನ್ನನ್ನು ನಾನ್ ನೋಡೋದಕ್ಕೆ ಮಕ್ಕಳು ನೋಡೋದಕ್ಕೆ ಸ್ಕೂಲ್ ಹತ್ರ ಹೋದಾಗಲೇ ಗಲಾಟೆ ಆಗೋಯ್ತು.
ಅಲ್ಲ ನಿಮ್ಮನ್ನ ನೋಡಕ್ಕೂ ಬರಕ್ಕಾಗಲ್ಲ ಅವ್ರ ಪಾಪ.
ಅದಕ್ಕೆ ಪಾಸ್ಪೋರ್ಟ್ ಕೊಡಕ್ಕೂ ನಾನು ಕೂಡ
ಪಾಸ್ಪೋರ್ಟ್ ಕೊಡಿ. ಅಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಏನಿದೆ?
ಮೇಂಟೆನೆನ್ಸ್ ಏನು ಇಲ್ಲ. ಅವರು ಪರ್ಮನೆಂಟ್ ಅಲಿಮೋನಿ ಕೇಳಿದ್ರು. ದುಡ್ಡು ಅನ್ನೋದ್ರ ಬದಲಾಗಿ ನಮ್ಮ ಆಸ್ತಿ ಒಂದು ಶ್ರೀರಾಮ್ಪುರದಲ್ಲಿ ಇದೆ, ಅದೇ ಬರ್ಕೊಡ್ತೀವಿ, ಬಾಡಿಗೆ ಬರ್ತಾ ಇದೆ, ಅಟ್ಲೀಸ್ಟ್ ಅದ್ರ ತಗೊಳ್ಳಿ ಅಂದ್ರು. ಅವರು ಬಾಡಿಗೆದೆಲ್ಲ ನಾವು ಮೇಂಟೈನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ದುಡ್ಡು ರೂಪದಲ್ಲೇ ನಮ್ಗೆ ಬೇಕು ಅನ್ನೋ ತರ ಕೇಳಕ್ ಶುರು ಮಾಡಿದ್ರು.
ಬಿಟ್ಟು ಕೊಟ್ಬಿಡಿ.
ತಾತನ ಆಸ್ತಿ ಎಲ್ಲ ಒಂದ್ ಕಡೆ ತಲತಲಾಂತರದಿಂದ ಬಂದಂತ ಆಸ್ತಿ ಮೊಮ್ಮಕ್ಳಿಗೆ ಇರ್ಲಿ ಅನ್ನೋ ತರ ಯೋಚನೆ ಮಾಡ್ಕೊಂಡು
ಅವ್ರಿಗೆ ಬೇಡ ಅಂತಲ್ಲ.
ಅದಕ್ಕೆ ಸೆಟ್ಲ್ ಆಗೋ ಚಾನ್ಸಸ್
ಆ ಪ್ರಾಪರ್ಟಿ ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ, ದುಡ್ಡು ಬೇರೆ ಕೊಡಿ. ನಿಮ್ಗೆ ಇಟ್ಕೊಳ್ಬೇಕು ಅಂತ ಆಸೆ ಇದ್ರೆ ಅದೇ ಇಟ್ಕೊಳ್ಳಿ.
ಅದಕ್ಕೇನೆ ಇನ್ನೂ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ವಿ.
ವಾಟ್ ಇಸ್ ದ ಅಮೌಂಟ್ ಯು ವಾಂಟ್ ಮೇಡಮ್?
My lord, I have to ask my client, what has happened, my lord, regarding passport? Allow passport.
ಪಾಸ್ಪೋರ್ಟ್ ಆಗೋಯ್ತು, they are going to hand it over.
ಅಲ್ಲ, children now are the majority ಓದಕ್ಕೆ ಹೊರಗಡೆ ಹೋಗ್ಬೇಕು ಒಂದು. ಇನ್ನೊಂದು they are into.
ಪಾಸ್ಪೋರ್ಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ they are handing over in the court. ಕೇಳಿಲ್ಲ ನೀವು?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಅದ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. But the Supreme Court has directed to give them a letter of apologies. ಅದು he is trying to tag both and blackmail, my lord.
Forget apology. Why are you bothered about it?
No, he will not give. He has put a condition, my lord, in that affidavit, in that apology. He has said.
You want
that,
to make it an ego issue or you
no,
want
no,
to
I don't want to make an ego issue. I
want the apology letter?
No, Supreme Court only directed to give him an apology letter.
Then let Supreme Court take care of it. Now how much is the alimony that you want?
Alimony 40 lakhs, my lord. Actually, she is not asking.
Our claim 40 lakhs. ನೀವೇನು?
ಅದನ್ನ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲೂ ಹೇಳಿದ್ರು.
ಆಯ್ತು, ನೀವು
ಇಮಿಡಿಯೇಟ್ ಆಗಿ ದುಡ್ಡು ರೈಸ್ ಮಾಡೋದು ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ ಅಂತ.
ಯಾವಾಗ ರೈಸ್ ಮಾಡ್ತೀರಾ, ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಸಬ್ಮಿಷನ್, ಇಲ್ಲೊಂದು ಸಬ್ಮಿಷನ್ ಮಾಡೋದು ಬೇಡ ಸ್ವಾಮಿ.
ಬೇಡ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡಿ.
ಅದರಿಂದ ತಾವು ಸ್ವಲ್ಪ ಸಮಯ ಕೊಡಿ. ಅಷ್ಟರೊಳಗಡೆ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಮಾಡಿ ಏನೋ ಒಂದು ಎಲ್ಲಾ ಕೇಸ್ಗಳು ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ ಅಂತಾರೆ.
ಬಟ್ ಪಾಸ್ಪೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೋದು ತಾನೆ?
ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಹೋಗಿದೆ.
ಇದು ಒಂದು ರೆಕಾರ್ಡ್ ಮಾಡೋಣ.
ಫೆಬ್ರವರಿನಲ್ಲಿ
ಇದನ್ನು ಎತ್ಕೊಂಡು ತೋರಿಸ್ತಾರಲ್ಲ ಅಷ್ಟೇ. ಕೊಟ್ಬಿಡಿ.
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆದ್ರೂ ಕೂಡ ಪಾಸ್ಪೋರ್ಟ್ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಫಸ್ಟ್ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಬಂದಾಗ ನಾನು ಹೇಳಿರೋದೆ, ಆಕೆನ ಡೈರೆಕ್ಟ್ ಆಗಿ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ನಾನೇ ಹೇಳ್ದೆ, ಪಾಸ್ಪೋರ್ಟ್ ಮಕ್ಕಳಿಗೆ ತೊಂದರೆ ಆಗೋ ತರ ಇದ್ರೆ ನಾನೇ ಅಡ್ವೈಸ್ ಮಾಡಿ ಕೊಡಿಸ್ತೀನಿ. ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನಿಮ್ಗೆ ಹೇಳಿ ಅಂತ ನಾನೇ ಖುದ್ದಾಗಿ ಮಾತಾಡಿದ್ದೀನಿ.
ನೀವ್ ಇದ್ದಾಗ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕು.
ಆದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಒಂದೇ ತರ ಯೋಚನೆ ಮಾಡೋ ತರ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಒಂದೊಂದು ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಬದಲಾವಣೆ ಆಗ್ತಾ ಇದ್ರೆ
ಇಲ್ಲ, ಇಲ್ಲ.
ನಾನು ಇವ್ರಿಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡೋದ್ ಕಷ್ಟ ಆಗುತ್ತೆ. ಡೈರೆಕ್ಟ್
ಇಲ್ಲ,
ನಾನೇ ಮೀಡಿಯೇಷನ್ ಸೆಂಟ್ರಲ್ ಅಕ್ಕಿ ಹತ್ರ ಮಾತಾಡಿದಾಗ ಸರ್ ನನ್ಗೆ ಏನೂ ಬೇಕಾಗಿಲ್ಲ, ನನಗೆ ಆ ದುಡ್ಡು ಬೇಕಾಗಿಲ್ಲ, ಏನೂ ಇಲ್ಲ, ಪಾಸ್ಪೋರ್ಟ್ ಕೊಡ್ಸಿ ನನ್ಗೆ ಮಕ್ಳಿಗೆ ನೋಡ್ಸಕ್ಕೆ ಅವ್ರು ತೊಂದರೆ ಮಾಡದೇ ಇದ್ರೆ ಸಾಕು ಅಂದ್ರು. ನಾನು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಆಯ್ತಮ್ಮ ಆ ಒಂದು ರೀತಿನಲ್ಲಿ ಕೇಳ್ತಾ ಇರೋದ್ರಿಂದ ನಾನೇ ಮುಂದೆ ನಿಂತ್ಕೊಂಡು ಪಾಸ್ಪೋರ್ಟ್ಗಳನ್ನ ಕೊಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ. ಆವತ್ತೊಂದ್ ದಿವಸ ಬೈ ಚಾನ್ಸ್ ಮೀಡಿಯೇಟರ್ ಇರ್ಲಿಲ್ಲ, ನಾನೇ ಡೈರೆಕ್ಟ್ ಆಗಿ ಪಾರ್ಟಿ ಹತ್ರ ಮಾತಾಡಿದ್ದು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಮೀಡಿಯೇಷನ್ ಬಂದಾಗ ಅವರು ನನ್ಗೆ ಅದ್ರ ಜೊತೆಗೆ ದುಡ್ಡು ಬೇಕು ಅಂದ್ರು. ಅವಾಗ ನಾನು ಅವ್ರನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ಏನು ದುಡ್ಡು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಒಂದು ಆಸ್ತಿನೇ ಬರ್ಕೊಡ್ತೀವಿ ಸರ್, ಇಮಿಡಿಯೇಟ್ ಆಗಿ ದುಡ್ಡು ರೈಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ. ನಾನು ಅದನ್ನು ಕೂಡ ಅವ್ರಿಗೆ ಆಫರ್ ಕೊಟ್ಟೆ, ನೋಡಮ್ಮ ಅದ್ರಲ್ಲಿ ಬಾಡಿಗೆ ಬರ್ತಾ ಇದೆ, ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇರುವಂತ ಆಸ್ತಿ, ನಿಮ್ಗೆ ಬೇಕಾದ್ರೆ ಅದನ್ನೇ ಇಟ್ಕೊಳ್ಳಿ. ಇಲ್ಲ ಇಲ್ಲ ನನ್ಗೆ ದುಡ್ಡೇ ಬೇಕು ಅಂತಂದ್ರು.
We'll record it so that they can't change it.
Yes, ma'am.
ನಾನು
Once we record it,
submission
then
ಮಾಡಿದ್ನೋ,
their submission will also be there, your submission will also be there, nobody can change it. ಇದು ಒಂದ್ಸ ರೆಕಾರ್ಡ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತೆ ಒಂದೊಂದ್ಸತಿ. Boundaries are drawn.
ಖಂಡಿತವಾಗಿ ರೆಕಾರ್ಡ್ ಮಾಡಿ ನಾನು ಏನೇ ಮಾಡಿದ್ರು ಕೂಡ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಆಗಿ ಕೋರ್ಟ್ ಮುಂದೆ ಸಬ್ಮಿಷನ್.
Yes.
My lord,
That is why, with you being there, it should settle. It should not,
ಪಾಸ್ಪೋರ್ಟ್ ಕೊಡ್ಸ್ತೀವಿ
for
ಅಂತ
the
ನಾವೇನೆ
small things, it should not get. Yes, madam.
Ala, 40 laksha, what is she asking for is, she doesn't want it as maintenance. In fact, her 25,000 pounds in London in her account is there, my lord. That she is asking, that's all.
In your account,
Joint account.
joint.
In the husband and wife, they were doing a business there in London. So her share of 25,000 pounds.
So we record that you don't want alimony.
Yes, my lord, she doesn't, this has been our stand from the
No
beginning.
maintenance, no alimony, only 25,000.
25,000 pounds. So now she's saying it'll come up to 40 lakhs.
115 rupees, it comes to around 30 lakhs.
The 40 lakhs, that, and her jewelry is also there, which they're denying, my lord. Her jewelry is in London.
25,000 pounds ಸುಮ್ನೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಡಿ, 30 lakhs 40 lakhs ಎಷ್ಟಿದೆಯೋ ಅದು ಕರೆನ್ಸಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಕನ್ವರ್ಷನ್ ರೇಟ್ ಅವ್ರು ನೋಡ್ಕೊಂತಾರೆ. ಇದೆಯಾ 25,000 pounds?
ನನಗೆ ಫೀಸ್ ಕೊಡೋದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಕಮ್ಮಿ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ ಇದೆಯೋ ಇಲ್ವೋ ಅಂತ ನನ್ಗೆ ಗೊತ್ತಾಗ್ತದೆ. ಮಾತಾಡಿ
We'll record this, so boundaries are drawn. So you don't, apology letter ella, we don't want to get involved in, you see what you want to do before the Supreme Court.
One more submission. I stand by it. Why? Because even before Justice Nataraj regarding 482 petitions, this was the offer put forth by my client, my lord. Passports and all other supplementary documents to the passport and her 40,000 and her jewelry. These were the demands, my lord. I am not changing this at all.
Yes.
These three were the
Lord.
demands even then and even now.
Learned counsel for respond number 2,
Yes.
wife submits that the wife does not seek for any permanent alimony or maintenance amount from the petitioner husband.
Yes.
Our submission is that there is an amount of rupees, amount of UK pounds, 25,000 lying in a joint account in ಯಾವ bank?
London, I don't know the details, my lord.
Find out ಮಾಡಿ ಹೇಳಿ.
I have to ask her, I have to call her up and ask.
Yeah,
I've
fine.
ಕೇಳ್ಬಿಟ್ಟು ನಾನು I will.
ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಹೇಳಿ. So it is clear.
Yes, yes, my lord. I have been, my learned friend also will not deny this, Alva sir. This has been my three demands, even before Justice Nataraj. There's no change.
25,000 pounds lying in the joint account maintained in blank bank, blank branch,
Yes.
blank city.
ಲಂಡನ್ ಅಂತ.
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Learned counsel, secondly, she submits that the ಎಷ್ಟು ಮಕ್ಕಳು?
Two.
ಇಬ್ಬರು ಮಕ್ಕಳು,
That
ಒಂದು
they
ಗಂಡು
two-
ಒಂದು ಹೆಣ್ಣು, ಒಂದು ಗಂಡು ಒಂದು ಹೆಣ್ಣು.
One hennu first,
The
ಆಮೇಲೆ
two children, one son and one daughter, have now attained majority.
they're not yet.
ಇವತ್ತು
The elder one will attain majority in the recent few years. So for education, yes.
Years.
She is, I think 15 years, madam. 15 or something.
The
15 ಮತ್ತೆ
children,
9.
one son and one daughter, are also planning to study abroad.
And we can play, they're into sports, my lord, especially the younger one.
ಒಂದು ನಿಮಿಷ. Planning to study abroad. As also travel abroad
For sports, my lord, they are very
for
interested in
their sports activities, etc.
Yes.
The passport, I mean, withheld by the petitioner husband is coming in the way of the children traveling
In
abroad.
fact, under 11 cricket ಅಲ್ಲಿ he was not selected only because they didn't have passport. ನಾನೇನ್ ಮಾಡ್ಲಿ? This is my concern. This is the concern of the wife, mother.
Not fair, not fair.
ಅಲ್ಲಲ್ಲ, ನನಗೆ ಈ
It
ವಿಷಯ
is his
ಈ ವಿಷಯ
children.
ಹೇಳಿರೋದನ್ನೇ
It is his.
ಈ ವಿಷಯ ಹೇಳಿರೋದನ್ನೇ ಈ ತರ ಎಲ್ಲ ಆಗಿದೆ ಅಂತ 1 ತಿಂಗಳು ಮುಂದೆ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಾನು ಹೇಳಿದ್ದೀನಿ, ಕೊಟ್ಬಿಡಿ ಪಾಸ್ಪೋರ್ಟ್.
Not fair. Tell your client it's not fair. It is his own children. That he is playing with the life of his own children.
ನಿಜ.
Not for, he may have 100 disputes with his wife.
ಐ ಆಮ್ ಫುಲ್ಲಿ ವಿತ್ ದ ಕೋರ್ಟ್.
Let him fight with his wife if he wants to. Let both of them keep on fighting for eternity. But not the children cannot be used as pawns.
ಐ ಫುಲ್ಲಿ ಅಗ್ರಿ ವಿತ್ ದ ಕೋರ್ಟ್.
Apart from the above, and as such she asks, she submits that the passports may be returned so as to be made use of for the purpose of travel of the children. Learned counsel for the petitioner would submit that in one of the matters pending before the Honorable Apex Court,
ಮೂರು ಪೆಟಿಷನ್.
ಇಲ್ಲ ಅದಿದ್ದಕ್ಕೆ ಹಾಕೋದ್ ಬೇಡ ಸ್ವಾಮಿ. Every time they do that, they attack some other case to this.
ಡಿಫಾಮೇಶನ್ ಕೇಸ್ ಹಾಕಿದ್ರು. ಒಂದು ಇವರು ಮತ್ತೆ
ಇವಾಗ ಅದು ಯಾವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ?
ಲಾಸ್ಟ್ 26/2 ಇತ್ತು.
ಹಾ.
ಆಫ್ಟರ್ 2 weeks it may be listed ಅಂತ ಬಂದಿದೆ. 26/2
In one
ಇಂದ
of
2
the, in some of the matters which are listed before the Honorable Apex Court, the petitioner has undertaken to hand over the passport on the next date. The said submission answers the grievance of the respondent insofar as the passport is concerned. Be that it as it may, there would be nothing which prevents the petitioner to hand over the passport even before that date and report the handing over before the Honorable Apex Court. Considering that the school vacations are ensuing and there may be a requirement for the children to travel for their sports activities otherwise. You don't need to wait. Insofar as the return of the amount of the claim of the amount of 25,000 UK pounds, the counsel for the petitioner has submitted that the petitioner has offered a house in Srirampuram, Bangalore, which is rented out, which apart from which is valued at about
ಅರೌಂಡ್ 60 lakhs ಅಂತ ನನಗೆ ಹೇಳಿ.
which is valued at about rupees 60 lakhs. And if the respondent wife is willing to accept the same, he is willing to transfer the same in the names of the children. Alva?
Correct.
In the name of the children. The counsel for respondent wife submits that she is not interested in receiving a immovable property. So there is a requirement of funds for the education of the children. And as such, she would be happy with only the transfer of 25,000 pounds to the account of the respondent, which he confirms and undertakes will be used for the benefit of the children.
Very good.
If such a request not is complied with, let her withdraw all the proceedings. Our
If-
case ಇದೆ.
If our last submission is that if the passports are handed over and the amount of 25,000 pounds are transferred to the account of the respondent wife, all pending proceedings would be withdrawn.
Between the parties, my lord, not others.
In others yaar?
ಅವ್ರ others ಸೇರ್ಸ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Others yaar idarappa?
ಅದರಲ್ಲಿ ಅವ್ರ
I
ಸಿಸ್ಟರ್
can't say-
ಹಸ್ಬೆಂಡ್, ಅವ್ರ ಸಿಸ್ಟರ್ ಹಸ್ಬೆಂಡ್ ಅಂದ್ರೆ ವೈಫ್ ಸಿಸ್ಟರ್, ವೈಫ್ ಬ್ರದರ್ ಇನ್ ಲಾ ಅಂಡ್ ಇನ್ನೊಬ್ರು ಇಬ್ರು
Father.
ಫಾದರ್.
Get everything withdrawn.
No, my lord, he has made all defamatory statements, my lord, kindly.
But you can't, then you continue fighting.
No, not me, my lord, not me. The wife is ready to settle, but how can I talk on behalf of them, my lord? They have initiated proceedings because
See,
of the
it's your
defamatory statements
family.
that,
You want to bring a closure and let the children grow in a better atmosphere than what the vitiated atmosphere that is getting to be. You have to close all this.
yes, I have
Otherwise
been,
the atmosphere will get more vitiated. That you
yes,
should
my lord,
speak-
that is why Supreme Court has asked him to apologize, but he has not apologized as
speak to
per.
you should speak to your father also and get it withdrawn. It's in the interest of everybody.
Yes, my lord, but I can't right now talk
Things
about.
have happened, lot of things have happened. That doesn't mean that you are stuck there in the past.
All that they are requesting is for a proper apologies, my lord, which has not been complied with him. That is all.
ಏನಪ್ಪ ಅಪಾಲಜಿ?
ಅಪಾಲಜಿಗೂ ಕೂಡ ಕ್ವಾಶಿಂಗ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ವಿ, ನೀವು ಯಾವ ತರ ಹೇಳ್ತಿರೋ ಆ ತರ ಕೋರ್ಟ್ಗೆ ಅಪಾಲಜಿ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಆಗ ಅವ್ರು ಏನಂದ್ರು, 2 ನ್ಯೂಸ್ ಪೇಪರ್ಗಳಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕು.
No, wrong. I didn't make it, my lord. Justice Nataraj directed him to do this, not me. I didn't say, sir, ನಾನು ಹೇಳಿಲ್ಲ. ನಾನು 2 paper
ಇವಾಗೇನ್ ನಿಮ್ಗೆ ಪಬ್ಲಿಕೇಶನ್ ಬೇಕಾ, ನಿಮ್ಗೆ ಲೆಟರ್ ಬೇಕಾ?
In the proper way, my lord, it has to be
ಪ್ರಾಪರ್
done.
ವೇ ಅಂದ್ರೆ ಏನ್ ಬೇಕು ಹೇಳಿ?
He has to apologize that all these statements made against so and so are false.
In the letter addressed to your father.
ಇಲ್ಲ ಅವರು ಮಕ್ಕಳ ಕಸ್ಟಡಿ ನನ್ನ ಹತ್ರನೇ ಇರ್ಬೇಕು ಅಂತ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ. ನಾವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ ಮಕ್ಕಳ ಕಸ್ಟಡಿ ಅವ್ರ ಹತ್ರ ಇರೋದ್ ಬೇಡ, ನಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತಿವಿ. ಆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮೇಲೆ ಡೆಫಮೇಷನ್ ಹೋಗಿರೋದು. ನಂತರ ಆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅವರು UK ಸಿಟಿಸನ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ಈ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಗೆ ಜುರಿಸ್ಟಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಪಿಟಿಷನ್ ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆ ಅವ್ರು MFA ಹಾಕೊಂಡು ಕೋರ್ಟ್ ನಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅಲ್ಲಿ ಕೇಸೇ ಕನ್ಕ್ಲೂಡ್ ಆಗಿಲ್ಲ, ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ. ಇಷ್ಟರಲ್ಲಿ ಒಂದು ಒರಿಜಿನಲ್ ಸೂಟ್ ಹಾಕಿ 40 ಲಕ್ಷ ಡ್ಯಾಮೇಜಸ್ ಕಟ್ಕೊಡ್ಬೇಕು, ಆ ತರ ಒಂದು ಡೆಫಮೇಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಫೈಲ್ ಮಾಡಿರೋದಕ್ಕೆ ಅಂತ ಒಂದು OS ಹಾಕಿದ್ದಾರೆ. ಅದು ಕೂಡ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಆಗ್ತದೆ.
She submits that all proceedings filed by respondent wife would be withdrawn. And what about the others? You will persuade them.
I have to ask them, my lord, like right now,
And
this,
insofar as the other proceedings filed
in this,
by the other family members of the wife, she will
Get
seek
instructions.
instructions and make her submissions. I am in the considered opinion that when most of the issues have been sorted out between the husband and wife, it would be in the interest of the husband and wife, as also the children who have been unnecessarily dragged into the proceedings, that all proceedings are resolved by withdrawal or settlement at the earliest. Hence, the parties are directed to explore that possibility and make their submission. Released on 20th March.
ಅದವರೆಗೂ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಟೆಂಡ್.
Interim order earlier granted is extended. So now only limited, this one is your other criminal proceedings, everything else is getting solved. As other, if you solve it, everything gets over.
ಅಲ್ಲ affidavit ಒಂದು hangings ಓಡಿದೆ.
ಅದು ಅಲ್ಲಿ ನೋಡ್ಕೊಂತಾರೆ.
ಅದೇ
ಇದೊಂದೇ ಇರೋದು ಇವಾಗ. ಅಷ್ಟೇ.
ಅದು affidavit ಕೊಟ್ಬಿಟ್ರೆ nothing to do, my lord.
ಇದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕ್ಸ್ಕೊತೀನಿ ಮೇಡಮ್ ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ.
ಏನ್ ಅಫಿಡವಿಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಕೊಡಿ. ಅವ್ರ
ಅವ್ರ
ಫಾರ್ಮ್ಯಾಟ್
affidavit
ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಇನ್ನೇನ್ ಬೇಕು ನಿಮ್ಗೆ?
ಇದು
ನಾವೆಲ್ಲ
ಒಂದೇ
ಕೊಟ್ಟಿದ್ವಿ, ಎಲ್ಲ
ಕೊಡಿ, ನಮಗ್ ಕೊಡಿ. affidavit.
ಕಳ್ಸಿದ್ವಿ. ರೈಟ್, ನೋ, ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಮಧ್ಯಾಹ್ನ ಕೊಡಿ.
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಇತ್ತು, ಅದು ಅಲ್ಲ ಅವ್ರಿಗೆ ಕಳಿಸಿ.
affidavit ನೀವು share ಮಾಡಿ.
ಮಧ್ಯಾಹ್ನ ಕೊಡಿ. ಪ್ರಿಂಟ್ ಔಟ್ ತಗೊಂಡ್ ಕೆಳಗಡೆ ಪ್ರಿಂಟ್ ಔಟ್ ತಗೊಂಡ್ ಬಂದ್ ಕೊಡಿ.
ಅಯ್ಯೋ ಇಲ್ಲ, ಇವತ್ತಾಗಲ್ಲ ಸ್ವಾಮಿ, ಸ್ಲೈಟ್ಲಿ ಬಿಸಿ, my lord. I will
ನೀವು ಆಲ್ರೆಡಿ ಇದೆ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಪ್ರಿಂಟ್ ಔಟ್ ತೆಗೆದುಕೊಡಿ.
ಅದು ಕಂಡೀಷನ್ಸ್ ಹಾಕಿದ್ವಿ ಅಷ್ಟೇನೆ.
ಡಿಮ್ಯಾಂಡ್ಸ್ ಏನೇನ್
Demands.
ಬೇಕು ಅಂತ
We'll see whether your affidavit is reasonable or not.
ಇನ್ನೊಂದ್ ದಿನ ಬೇಕಂದ್ರೆ ಹಾಕೊಳ್ಳಿ, ನಾ ಕೊಡ್ತೀನಿ. ಇವತ್ತು ಸ್ವಲ್ಪ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ I have work, my lord.
ಇನ್ನೊಂದ್ ದಿನನಾ?
ಬೇಕಂದ್ರೆ
Released on-
ಹಾಕೊಳ್ಳಿ, ನಾನು ನನ್
Released
ಕ್ಲೈಂಟ್
on 5th.
ನನ್ ಕ್ಲೈಂಟ್ನು ಬರಕ್ ಹೇಳ್ತೀನಿ. ದೆನ್
ಕ್ಲೈಂಟ್ ಏನ್ ಬೇಡ.
ಅಯ್ಯೋ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಇಲ್ದಿರ ನಾನೇನು ಮಾಡಿದ್ದೆ.
ಅಫಿಡವಿಟ್ ಅಷ್ಟೇ
ಇಲ್ಲ
ಕೊಡಿ.
ಇಲ್ಲ, ಇದೇ ಜಾಸ್ತಿ ಆಗೋಯ್ತು. ಬಟ್ ಐ ಆಮ್ ವೆರಿ
ನಿಮ್
ಕಾನ್ಫಿಡೆಂಟ್
client
ದಟ್ ಶಿ ವಿಲ್ ನಾಟ್ ಡಿನೈ ಆಲ್ ದಿಸ್
ನಿಮ್
ಥಿಂಗ್ಸ್.
ಕ್ಲೈಂಟ್ ಏನ್ ಅಫಿಡವಿಟ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಲ್ಲ, ನೀವೇ ಮಾಡೋದ್ ಕೊಡಿ.
ಇಲ್ಲ ಇಲ್ಲ, ನಾನು ಐ ವಿಲ್ ಡೂ ಇಟ್ ಆಸ್ ಪರ್ ದೇರ್ ರಿಕ್ವೈರ್ಮೆಂಟ್.
Released on 5th. Yes.
Serial number 23.
Yes. Who is for the respondent?
It's an application under 452, my lord. Release of the gold.
Release.
Interim custody at short. I'm an NBFC. During the course of investigation, my lord, the gold came to be seized from the branch of the petitioner company.
What
Thereafter,
has happened to the proceedings?
the proceedings, my lord, now, my lord, it is pending trial, it appears. Now, my lord,
In a trial ಅಲ್ಲಿ ಇದೆ.
the magistrate at the first instance, my lord, rejected our application. Thereafter, we presented a revision application for the learned session judge. Learned session judge, my lord, setting aside the order of the magistrate, granted the interim custody, my lord, and this court, my lord, had granted the interim stay immediately when we filed this petition. But admittedly, the seizure has taken place from the custody of the petitioner company. And upon the gold ornaments being, my lord, offered as security, the loan was being sanctioned. And neither we are in a position to recover the loan, my lord, in view of this seizure. And since
No, if it is, you can't sell it.
we will not, my lord, ultimately, my lord, you will come for at least settlement if the interim custody is handed over to us.
ಯಾರು settlement?
ಯಾರು ಆಫರ್ ಮಾಡಿದ್ರು ಸೆಕ್ಯೂರಿಟಿ
ಅವ್ರು ಏನ್
ಅವರು ಓಡೋಗ್ಬಿಡ್ತಾರೆ. ಸೊ ಅಂಡ್ ಇನ್ ದ ಟರ್ಮ್ಸ್ ಆಫ್ ದ
Or against criminal proceedings are there.
ಇವ್ರ ಮೇಲೆ ಇಲ್ಲ, ಯಾರ ಮೇಲೆ ನಮ್ಮ
ನಿಮ್ ಕೊಟ್ಟವ್ರ ಮೇಲೆ ಇಲ್ವಾ?
ಇಲ್ಲ. They say that in some other case it was seized and there they recorded a voluntary statement. So
So the pledgee is not the,
that is not the case also. Complaint.
not the accused.
Huh.
They are not the accused.
They are seeking the ornaments, stolen ornaments are there.
They will retain in their custody without disposing. They will retain in their custody without disposing. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾಕೆ ಇರ್ಬೇಕು? ಅವ್ರ ಹತ್ರ ನೀಟಾಗಿ ಸೇಫ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಎಷ್ಟು ಗ್ರಾಮು ಅಷ್ಟು ಗ್ರಾಮೇ ಇರುತ್ತೆ. ಏನಾಯ್ತು ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಏನಾಯ್ತು? ಮೇನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
In trial of the. In fact, my lord, this court has directed in identical circumstance to be kept in a safe custody ಅಂತ ಒಂದು ಆರ್ಡರ್ ಇದೆ. Identical sir. Xerox. Gold ornaments are involved, my lord. The last statement, my lord, I'll request you lordship to come to page number 8, last page, my lord, order portion. Both the criminal petitions are hereby dismissed. However, trial court is directed to take care of those articles which are seized and kept in to keep them in the safe custody till disposal of the case and after recording the evidence. The court has to give the finding after hearing the rival contentions with regard to who is entitled for the return of these goods, articles, and thereafter pass appropriate orders.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹತ್ರನೇ ಇದೆ, ನಿಮ್ಗೇನು ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ.
But in case of, my lord, ಇಲ್ಲಿ ಇವರು ರಿಲೀಸ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್. Sessions court has directed, my lord, directed for handing over of these gold ornaments to the complainant of.
Handed over to the complainant.
How? Sessions court, my lord, has set aside the order passed by the
Owner of
magistrate.
the article.
The owner. Ownership has been established.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
What are you challenging?
ಮಾಡ್ತಾರೆ ನಮ್ಗೆ
ಮುಂಚೆ ಹೇಳಿದ್ರೆ it's not been given to me ಅಂದ್ರೆ, so it's in the court ಅನ್ಕೊಂಡು.
Now, my lord, the indemnity bond that they have executed before the bank, my lord, would clearly show that it is not a proceed of a crime or it is exclusively belonging to them. And I have done my due diligence, my lord, and I have offered the.
Your due diligence was not good enough.
At that stage, my lord, we did not.
Not good. If it is owned by somebody else and it's been given to the owner,
And even, my lord, the petitioner had not produced, my lord, any.
you proceed against whoever you did your due diligence, not against the owner. Owner cannot be denied. Owner ಬದಲು ನಿಮ್ಗೆ ಕೊಟ್ರೆ ಯಾರು ಓನರ್ ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾ?
ಇಲ್ಲಿ ಓನರ್ ಅಂತ ಹೇಳೋದೇ ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ. That is the precise case. Kindly come to annexure C, my lord. Annexure C, page 31. ಈ ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ನಾನು ವಾಸವಾಗಿದ್ದುಕೊಂಡು ಗರಣಿಯಾಗಿರುತ್ತೇನೆ. ದಿನಾಂಕ
The petitioner is the owner of the stolen property under PF 35 and 36 of 2000. She had filed a release of the properties, page 18. He is the owner.
Sir, that is a finding that is recorded by the learned session judge, my lord. The complaint may kindly be looked. Complaint, my lord, your lordship.
Then she is the owner. She has produced the receipts.
Kindly see, my lord, the complaint that at page, at annexure C, my lord.
Page?
Annexure C, page 31. D1. ನಾನು ಈ ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದುಕೊಂಡು ಗೃಹಿಣಿಯಾಗಿರುತ್ತೇನೆ. ದಿನಾಂಕ 28/1/27 ಮಧ್ಯಾಹ್ನ 11 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನಾನು ಮನೆಗೆ ಬೀಗ ಹಾಕಿಕೊಂಡು ಬೀಗವನ್ನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಬಾಡಿಗೆ ಇರುವ ಶ್ರೀಮತಿ ಕುಮಾರಮ್ಮ ಅವರ ಮಗಳಾದ ಶ್ರೀಮತಿ ಅವರಿಗೆ ಕೈ ಬೀಗವನ್ನು ನೀಡಿ 1 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಯಜಮಾನರು ಬರುತ್ತಾರೆ, ಅವರಿಗೆ ಬೀಗ ಕೊಡಿ ಎಂದು ತಿಳಿಸಿ ಹೋಗಿದ್ದು. ನಂತರ 1 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಯಜಮಾನರು ಬಂದು ಬೀಗ ತೆಗೆದು ಮನೆಯಲ್ಲಿರುವಾಗೆ ನಾನು ಸಹ ಸಂಜೆ ಮನೆಗೆ ಬಂದು ರೂಮ್ನ ಬೀರು ತೆಗೆದು ನೋಡಲಾಗಿ ಬೀರುವಲ್ಲಿಟ್ಟಿದ್ದ 2 ಎಳೆ ಚಿನ್ನದ ಅವಲಕ್ಕಿ ಸರ 32 ಗ್ರಾಂ, 2 ಜೊತೆ ಚಿನ್ನದ ಓಲೆ 6 ಗ್ರಾಂ, 4 ಉಂಗುರ ತೂಕ 24 ಗ್ರಾಂ, 4 ಗೋಲ್ಡ್ ಕೇಸ್ ಲೇಡೀಸ್ ವಾಚ್ ಹಾಗೂ 5,000 ನಗದ ಹಣ, ಒಟ್ಟು 1,50,000 ಆಗಿರುತ್ತದೆ. ಇದನ್ನು ಯಾರೋ ಕಳ್ಳರು ಕಳ್ಳತನ ಮಾಡಿಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನಮ್ಮ ಒಡವೆಗಳನ್ನು ಕಳ್ಳತನ ಮಾಡಿಕೊಂಡು ಹೋಗಿರುವ ಆರೋಪಿಗಳನ್ನು ಪತ್ತೆ ಮಾಡಿ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಿ ನಮ್ಮ ಒಡವೆಗಳನ್ನು ನಮಗೆ ಕೊಡಿಸಬೇಕಂತ ಈ ಮೂಲಕ ಕೇಳಿಕೊಳ್ಳುತ್ತೆ. ಈ ಮನೆಯಲ್ಲಿ ಒಡವೆ ಕಳ್ಳತನ ಆಗಿರೋ ಬಗ್ಗೆ ನಮಗೆ ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಮ್ಮವರ ಮೇಲೆ ಅನುಮಾನ ಇರುತ್ತದೆ. This is only, my lord, on the basis of a suspicion, my lord, the complaint.
There is a claim as regards ownership.
There is a claim, my lord. Now, my
Just
lord,
pledged with you.
Kindly take the order passed by learned magistrate. Learned magistrate has rejected the claim, my lord. Kindly come
Page number?
on side. Page 51, my lord. Page 51. 51.
Fifty-one is the bail order.
Remand, I'm sorry.
Where's the magistrate order?
I'll just. Your lordship, my lord, at page 65, stand correct. 65 is the revision order, my lord. The magistrate order, I'll just point out. 1 minute.
One double rope, gold ಅವಲಕ್ಕಿ chain, one gold ring. ಎರಡೇ ಸೀಸ್ ಆಗಿರೋದು ಬಾಕಿ ಎಲ್ಲ ಇನ್ನ ನಿಮ್ಮ ಹತ್ರನೇ.
ಆಮೇಲೆ 2 FIR ಇದೆ ಸ್ವಾಮಿ, annexure B and C if your lordships will see. Multiple
gold rings.
Yes.
One pair gold ear studs, yes.
Well.
Where is the magistrate order?
51 to 54 ಎಲ್ಲಿದೆ ಅಮ್ಮ? My lord, page 52 ಅಲ್ಲಿ ಕೆಳಗೆ ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಆರ್ಡರ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 451 and 457. No, bottom portion, page 52. On the bottom portion, my lord, it's hand written. Order under section 450 and 457 of CRPC.
It will not be proper to release.
It is to be noted.
Been considered. They have considered the production of receipts in Indian.
The finding is the learned magistrate, my lord, has, since there are divergent findings, my lord, your lordship, my lord, in
Deshpande, when the complaint was filed, the items have been described. It was pledged with you. This very same items have been pledged with you. They have produced receipts for having purchased it.
But that also.
And that is why it's been released to the owner. Who are you? If you have a claim against the person who has pledged it, follow it through.
And now, my lord, by
You cannot be released. You cannot have any grievance as regard that. And more than that, you cannot even claim it for being released to you. It has to be given to the owner.
As regards that, my lord, the judgment of Ambalal, my lord, when interim applications are being made.
If it had been given to the accused, that was different. Owner kottag, you can't have any claim.
And now, my lord, if at the stage of deciding 451, my lord, there is one judgment. Ambalal judgment is very clear.
Yes.
My lord, in this judgment, the Honorable Supreme Court would say.
Page, para?
At para 11 onwards. Para 11. My lords will. Valuable articles and currency notes. With regard to valuable articles such as golden or silver ornaments or articles studded with previous stones, it is submitted that it is of no use to keep such articles in police custody for years till the trial is over. In our view, this submission requires to be accepted. In such cases, magistrate should pass appropriate orders as contemplated under 451 of CRPC at their level. For this purpose, if the material on record indicates that such articles belong to the complainant as whose house theft, robbery, or has taken place, then seized articles be handed over to the complainant after clause 1, my lord, preparing a detailed proper panchanama of such articles, taking photographs of such articles and a bond that such articles would be produced if required at the time of trial, and after taking the proper security. For this purpose, the court may follow the procedure of recording such evidence. Your lordship, para 13, your lordship, where I am emphasizing. For this purpose, the court may follow the procedure of recording such evidence as it thinks necessary as provided under 451 of CRPC. The bond and security should be taken so as to prevent the evidence being lost, altered, or destroyed. The court should see that the photographs of such articles are attested, countersigned by the complainant, accused as well by the person to whom the custody is handed over. Still, however, it is
by third party, complainant galla, accused galla, ಬೇರೆಯವ್ರಿಗೆ ಯಾರಿಗೋ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ by virtue of para 13, my lord, the learned magistrate at the first instance, my lord, has rejected, and the learned session judge, my lord, the word used is to record the evidence. Now, before the learned magistrate, my lord, these receipts are not produced. Kindly see, my lord, and at the sessions court stage also, they ought to have filed an application for production of the additional evidence as contemplated under the provisions of section 391 of CRPC for leading it. Nothing is, my lord, application is also not filed for producing it. Their perusal of page 52 would say that, my lord, both the parties were heard before the court of first instance.
Yes.
And the application for production of this evidence as is held in para 13, the receipts upon which the reliance is being kept, my lord. Those receipts ought to have been placed on record either before the original proceedings or before the revisional proceedings where the sessions judge was seized of the matter. Application is not filed under 391 for adducing the additional evidence or the evidence in that regard. Straight away, my lord, the same is taken note of. This is, my lord, a departure that is as directed by the Honorable Supreme Court in para 13, that is.
Yes, we'll deal with it. Third. Petitioner is before this court seeking for the following reliefs. On 29/1/2017, one Sarvasathamma had lodged a first information. Apart from other things stated therein, it was stated that a two-striped gold chain weighing Avalakki chain weighing 32 grams, ear stud weighing 6 grams, 4 golden rings weighing 20 gold rings weighing 24.9 grams, and one gold case watch had been stolen from the Almirah in her house. On which basis, crime number 151 of 2017 was registered by the Rajgopala Nagar Police Station for offences under section 380 and 454 of the IPC. During the course of investigation, the investigating officer, having been informed that these gold articles had been pledged with the petitioner who is in the business of gold loan, had visited the office of the petitioner, drew a panchnama on 30/1/2017 and seized the two-striped Avalakki gold chain weighing 32 grams, the gold ring weighing 4.3 grams, Albaki Erdo.
Chances are ಬೇರೆ ಇನ್ನೊಂದು FIR ಇದೆ ಸ್ವಾಮಿ. There are two FIRs. That's what I'm pointing out. Annexure B and C. Page 27, your lordship.
From the petitioner. The petitioner contended that one Lakshmamma had approached the petitioner stating that she was in need of money, and since she had a very good credit history with the petitioner, a loan was sanctioned by the petitioner on account of pledging of the two striped so-and-so weighing 32 grams and one gold ring weighing 4.3 grams to an extent of 61,000 rupees. The said Lakshmamma is stated to also have executed a declaration that the said gold ornaments are not proceeds of any crime. In that background, the petitioner filed an application under section 451 of the CRPC before the 7th Additional Chief Metropolitan Magistrate, seeking for interim custody of gold ornaments seized under PF number 36 of 2017. The original complainant, Saraswathamma, also filed an application under section 451 of the CRPC for release of the very same articles in her favor. The 7th ACMM by common order dated 8/2/2017 rejected both the application on the ground that
there are rival claimants.
There were rival claimants in the matter, and it would not be proper to release the said property to either party. Saraswathamma filed a criminal revision petition number 159 of 2017 before the 40th Additional City Civil and Session Judge, Bangalore, challenging the aforesaid order, which came to be allowed, while the impugned order dated 25/1/2018, challenging the same, the petitioner is before this. Shri Amit Deshpande, learned counsel for the petitioner, would submit that the gold articles having been pledged with the petitioner and a sum of rupees 61,000 having been advanced by the petitioner to Lakshmamma. The petitioner has a charge over the said gold articles. The petitioner, being a non-banking financial institution engaged in the business of gold loans, the interest of the petitioner would be adversely affected by way of the impugned order releasing the gold articles to Saraswathamma. The articles ought to have been released in favor of the petitioner on account of the charge that the petitioner had over the said gold articles. And on this ground, you submit that the impugned order is required to be set aside. Even you did not file any revision petition.
No, we didn't. We did not.
Or else the gold articles retained in the custody of the court and not handed over to Saraswathamma. Though respondent number 2 has been served, none appears, and the counsel has put in Wakalatnama, none appears for respondent number 2 today. In the present matter, it is not in dispute that a complaint was filed by Saraswathamma in crime number 151 of 2017, categorically identifying the two-striped Aulaki gold chain weighing 32 grams, ear stud weighing 6 grams, and 4 golden rings weighing 24.9 grams. The theft having occurred on 29/1/2017, it is on the very same day that Lakshmamma had approached the petitioner for pledging the items.
No, madam. The pledge form is.
6 ಅದೇ ಹೇಳಿದಿರಲ್ಲಪ್ಪ.
ಇಲ್ಲ, pledge form
29/1/2017.
ಇಲ್ಲ, pledge form ಅಲ್ಲಿ ಡೇಟ್ ಬೇರೆ 28/1/2017.
Para 6 ನೋಡಿ. The items having been identified by Srimati Saraswathamma and she having made specific allegation against Lakshmamma, and it is the same Lakshmamma who had pledged these gold articles with the petitioner. The trial, the revision court.
But a pledge form would state the name of Lakshmi, my lord. Lakshmi, not
Lakshmi, Lakshmamma. First,
ಇಲ್ಲ ಮತ್ತೆ ನಾಳೆ 452 ಅಪ್ಲಿಕೇಶನ್.
ಫಸ್ಟ್ ಕೆಂಪ, ಕೆಂಪಣ್ಣ, ಕೆಂಪಯ್ಯ, ಕೆಂಪಪ್ಪ ಹಂಗ್ ಶುರು ಆಗದು. The revisional court, having taken into consideration the said complaint which had been filed, the receipts produced by Saraswathamma as regards the purchase of the jewelry, the police report and the PF report PF report filed therein, as also taking into consideration the fact that the police did not have any objection to the release, as directed this release in favor of the original owner of the gold articles. In my considered opinion, the petitioner cannot find fault with the said order when when the owner of the gold jewelry has been deprived of the use of the said jewelry on account of theft having been committed. The petitioner cannot claim that it has a better right than the owner on the basis of an alleged pledge made by an accused in the criminal proceedings. The owner of the gold articles having produced receipts indicating evidencing the purchase of the gold articles, and the same having been considered by the revisional court, the petitioner cannot stand on a better footing than the original owner of the gold articles. the contention of Shri Amit Deshpande, learned counsel, that the security of the petitioner would be deprived of if the gold articles is returned to the owner cannot be sustained, inasmuch as the security which had been created in favor of the petitioner was as regards stolen goods, over which the person who had created security did not have any right. The pledger of the goods not having any right or title over the pledged goods, the pledgee, like the petitioner, cannot claim better right than the pledger, more so as against the original owner of the gold which has been stolen. The petitioner, having claimed that it had carried out due diligence and also having categorically stated that they said Lakshmamma had a very good credit history with the petitioner, it is for the petitioner to proceed against the said Lakshmamma on account of the loan which has been granted in favor of the said Lakshmamma, and cannot claim any interest, lien or the like as regards the stolen gold articles. In that view of the matter, I do not find any infirmity in the order passed by the revisional court. No grounds having been made out in the present petition, the petition stands dismissed.
Order, my lord, shall not come in the way while deciding ultimately 452, my lord, petition also. So finally, after trial, if the application is to be decided under 452, the observations made therein.
Needless to say that in the event of
The 452 application being decided after trial, the observations made herein.
there will be a finding that she is not the owner.
Trial evidence ಬಂದ್ಮೇಲೆ ಮತ್ತೆ if
ಹೌದು.
after confrontation, my lord, if my lords would hold that at this stage, these observation would not prejudice the cause, my lord.
How does it affect? The trial court has to come to a conclusion that this is not the gold of Sarasdhamma for you to claim make any.
ನಾಳೆ ಅವರು cross examination ಅಲ್ಲಿ certify ಇದನ್ನ bill, so if it is found to be, my lord, not that observation, my lord, that these
There will
observations.
be a finding, so you will have that. You can't have that here. Next.
Let me preempt ಅಂತ.
I have the petition.
Yes.
Since trial court proceedings is already disclosed.
Acquittal or conviction?
Acquittal.
Petitioner is before this court seeking for the following. Counsel for the petitioner has filed a memo dated 1/3/2024 signed by the petitioner, which reads as under. He submits that the proceedings before the trial court in crime number 193 of 2016 have ended in acquittal. In that view of the matter, petition is dismissed as infructuous.
Serial number 26. Sunil S. Narayan, 26.
Mr. Harish,
Yes, my lord, appearing for the respondent number 1, my lord.
respondent. Ikkada bani, respond. Ikkada petitioner. There is Mr. Sunil Narayan. Yes. Pass over. You are ready?
Yes, my lord.
You are ready, na?
Yes, my lord.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಎಷ್ಟು ಪೇಮೆಂಟ್ ಆಗಿದೆ ಒಂದು ಲಿಸ್ಟ್ ನಮ್ಮ ಪ್ರಕಾರ 1,90,000 ಪೇಮೆಂಟ್ ಆಗಿದೆ. ಪ್ಲಸ್ ಒಂದು ಸುಮಾರು ರಿಕವರಿ ಪೆಟಿಷನ್ಸ್ ಗಳು ಹಾಕೊಂಡಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಒಂದು ಟೇಬಲ್ ನಾನು ಮಾಡಿದ್ರೆ ಮಂಡೇ ಟು ಫಿಕ್ಸ್
My
ಮಾಡೋದು.
lord, actually, as per the court order, 60,000 ಏನು pending ಇದೆ, my lord, or memo.
ನೀವು ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ, ಅವರು ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ.
Yes,
We'll take it up on Tuesday.
Yes, much.
Both the councils are directed to place on record the respective statement of accounts indicating the total amounts paid and amounts due
Yes.
as on date. Released on 5th March.
27, Prasanna DP and connected matter.
The family matter, it is related to settle the matter, husband and wife.
Hmm.
They filed the divorce petition. Therefore,
13B ಹಾಕಿದಾರಾ?
13B actually ಇದರಲ್ಲಿ divorce petition ಅಲ್ಲಿ they are giving the consent by withdrawing all this petition to tell Marti ಅಂತ.
Land counsel for the petitioner submits that the disputes between the husband and wife are in the process of being settled. Given 2 weeks' time, they will report settlement by keeping the parties present. Released on 20th March at 2:30 PM. Interim order earlier granted is extended.
28, Jayana Jia.
Pass over.
29. Prasanna Kumar.
And 29, my lordship, I appear for the second respondent in this matter.
Yes.
But I pray for time to file fresh wakalat in this matter, my lord.
You're not signed Vakalatnama.
Mr.
Yeah,
GL
fine,
Vishwanath
but,
was earlier.
He has not signed in 2018 there. You've been with him from that time.
Yes, my lord. I file fresh wakalat, my lord.
ಮಾಡಿಲ್ವಾ
ಇಲ್ಲ
Sign
ಮಾಡಿಲ್ಲ
ಮಾಡಿಲ್ವಾ ನೀವು
ನಾನು ಮಾಡಿದ್ದೇನೆ
ಮಾಡಿದೀರಾ
ಮಾಡಿದ್ದೀನಿ.
ಫ್ರೆಶ್ ವಕಾಲತ್ನಾಮ ಏನಕ್ಕೆ ಬೇಕು
ಹೆಸರು ತೋರಿಸಿದ್ದು ಅಂತ
ಟೈಮ್ ಬೇಕಂತೆ
ತೋರ್ಸೋಣ
ಅಲ್ಲ
ಟೈಮ್ ಬೇಕಂತೆ
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ kindly show the name of Srimati Manasa B. Rao, my lord, in the columns.
ಅಷ್ಟೇ registry there print the name of Ms. Manasa B. Rao as that appearing for respond number 2 and delete the name of Sri GL Vishwanath as that appearing for respond number 2.
Bless.
Released on
9, not
5th March.
Please,
Please,
my lord.
It is made clear that no further
no
adjournment
further.
will be granted.
69 is also connected with this.
69.
But in 69, my lord, I undertake to file wakalat for R2, my lord. ಏನು ವಕಾಲತ್ ಫೈಲ್
69.
ಮಾಡಿಲ್ಲ.
Sri Ms. Manasa B. Rao undertakes to file Wakalatnama for respond number 2. Registry is direct to print her name as such. Once
Yes.
Wakalatnama is filed, connect with 29.
9, my lord.
Relist on 5th.
No, let them not seek adjournment. No, it's a very old man.
No, my
Released, no further adjournment ಅಂತ
Please,
ಹೇಳಿದೀವಲ್ಲಪ್ಪ
please.
ಇನ್ನೇನ್ ಬೇಕು
Not interim order.
My lord, may I
Interim
make a
order earlier
submission, my lord?
granted is 16.
My lord,
Yes.
make a submission. Instead of 5th, I have 7th, my lord. On 5th, my sins
7th ಆಗಲ್ಲ 5th 6th ಹೇಳಿ 7th is company day.
My lord, my sin is on Supreme. 7th, my lord, please.
7th ನಮ್ ಕಂಪ್ನಿ ಡೇನಪ್ಪ ನಿಮ್
Sorry, my lord. 8th, my
5th
lord.
or 6th
8th, my lord.
8th ನೀವೇ ಬನ್ನಿ
ಶಿವರಾತ್ರಿ ಅವರೊಬ್ಬರೇ ಬರ್ಬೇಕು.
Oh, I'm sorry, my lord.
ರಾತ್ರಿ ಎಲ್ಲ ಎದ್ದಿಟ್ಟು ಬನ್ನಿ Released on 12th March. No further adjournment would be granted.
Please.
ಆಯ್ತಾ 12th
11th March, my lord.
ನೀವೇನ್ ನೆಗೋಷಿಯೇಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಏನ್ ಮಾಡ್ತಾ ಇದೀರ ನೀವು ಎಷ್ಟು ಅಂತ ಡೇಟ್
Please, my
12th
lord.
March.
Oblige, my lord.
If arguments are not ನೀವು ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಇದು ಬರಿಬೇಕಾಗುತ್ತೆ.
Next time, Martin.
If arguments are not advanced by the respondent on that date of hearing, matter would be taken up for consideration on the basis of the submission made by the counsel for the
Alala,
petition.
that's up. Mala, we'll go on with the arguments, my lord.
You are taking it very lightly.
I'm sorry, my lord.
Yes.
Please.
Number 30.
Modest.
Somashekara PM.
My lord,
Yes.
I pray for a week's time.
Why?
My lord, senior is not,
Mic is there.
my lord,
Don't come away from the mic.
my lord, senior is not in Bangalore right now, that's why.
At the request of counsel for the petitioner, released on 12th March. It is made 5th March. 5th will be here.
Oh. 12th, my lord.
5th March, it's made clear that no further adjournment will be granted.
Great.
31. Akti Manjunatha Gowda. Corrected matter.
I mean 31.1. Yes. Where is Naveed?
On this matter,
Ready.
I'm ready for this.
Ashok.
Also, my lords.
Ashok.
Serial number 32, adjourn 33. C. Shankar Reddy.
Vidyashri.
ಅಲ್ಲ ಅದು ಅಡ್ವೊಕೇಟ್ ಟು ರಿಟೈರ್ ಆದ್ರು
Retire.
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ತೋರಿಸಿರೋ ಹೆಸರು. ಶಿ ಇಸ್ ದ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
For R2 ಅಂತಿದೆ.
ಇಲ್ಲ,
For R2 ನೇನಾ?
ಶಿ ಇಸ್ ದ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ? ರಿಟೈರ್ ಆದ್ಮೇಲೆ?
ಅಡ್ವೊಕೇಟೇ ಮೆಮೊ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕೊಂಡು ಕಳ್ಸಕ್ ಮೊದಲು
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದೆಯಾ? ಅಪ್ಲಾಯ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಬರೀ ರೆಸೀಟ್ ಹಾಕಿದ್ದಾರೆ. issue court notice to respond number 2, returnable by 23rd April.
Interim order may continue.
Interim order earlier granted is extended till next.
Serial number 34, adjourn 35. Prasanna Kumar P. Daroji.
Paso,
36. Prabhu Kumbugi.
Paso,
38. SPP.
yes, SCGP, 38.
In this matter, my lord, they challenged the not giving the custody of the accused, my lord, and verified password now. Finally, I submit.
Handing over of respond number 1. ಇನ್ನೇನ್ ಮುಗ್ದೋಗಿರ್ಬೇಕಿದು.
ಮುಗಿದೋಗಿದೆ ಅದಕ್ಕೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ.
Paso,
Case number 39, adjourn 40. Hamsa Endra.
Paso,
41. Sanjay Setia.
yes,
42.
either. There are too many obstacles.
For the petitioners, please, my lords, in this matter. But this is a petition under section 482 of CRPC, my lords, challenging the FIR registered by the first respondent police, my lords, on the basis of the complaint filed by the second respondent police. The complaint is under the section 38 and 41 of the Moneylenders Act and section 3 and 4 of the Prohibition of Charging Exorbitant Interest Act, please, my lords. My lords, the grievance of the petitioner is that the provisions of both the acts provide the powers are vested with the registrar of money lenders to register any complaint with respect to any of the offences committed under this act, please, my lords. There are precedents of this honorable court which also states that if any such violation of the act is found, it is the registrar and not the police who has to take necessary action. The police has taken action in violation of the settled provisions of the law, please, my lords. I'll take your lordships to the relevant provision, which is the
Judgment.
I have. There's a covered judgment of this honorable court. Sorry. I'm copy. The first judgment itself, my lords, starting from page 1. The relevant portion, my lords, starts at page 36, 34, please, my lords. Page 34, para 10. It is the case of the prosecution that the complainant, along with the staff and punch witnesses, entered into the premises of the respective petitioner, and they have seized the documents. But in this connection, and to know the powers and procedure for such entry, inspection, and seizure of the documents, Section 15 of the Karnataka Moneylenders Act is the relevant provision under which reads as under power of the authorized office to require production of records or documents and power of entry, inspection, and seizure. The registrar, assistant registrar, or any authorized by the state government in this officer authorized by the state government in this behalf may, for the purposes of verifying whether the business of money lending is carried on in accordance with the provisions of the act, enter the premises of the moneylender or any person who is, in his opinion, is carrying on the business of the money lending and call upon him to produce any record or document relating to such business. And every such moneylender or person shall allow such inspection and produce any such record or document. The registrar, assistant registrar, or the officer referred to in subsection 1 may, for the purpose of the said subsection, search the premises and seize any record and document as may be necessary. The record or document seized shall be retained only for the such period as may be necessary for the purpose of examination, prosecution, or any other legal action, provided that the provision of section 102 of CRPC shall so far as may be applied to such certain seizure,
Yes.
provide.
The petitioners are before this court seeking for the following reliefs. Petitioner is before this court. Respondent number 1, police, based on a complaint dated 16/1/2018, filed by respondent number 2 as registered FI and crime number 15 of 2018 against the petitioner for offences punishable under section 38 and 41 of the Karnataka Moneylenders Act 1961 and section 3 and 4 of the Karnataka Prohibition of Charging Exorbitant Interest Act 2004. The second respondent being the police inspector of police attached to Central Crime Branch, NT Pete, Bengaluru. The contention of the petitioner is that the second respondent is not the authorized officer under the Karnataka Moneylenders Act 1961 to lodge a complaint, carry out any search or seizure of any documents. And it's only the registrar under the Moneylenders Act, Karnataka Moneylenders Act 1961, who can do so. In this regard, he places reliance on the decision of a coordinate bench of this court rendered on 22nd June 2017 in criminal petition number 101569 of 2016 and other connected matters. More particularly, para 11 thereof, which is reproduced hereunder for easy reference. On the basis of the above, he submits that the genesis of the proceeding itself being improper, the proceedings have to be quashed. Heard, so and so perused papers. A perusal of para 11 of the aforesaid judgment in Sriman's case would categorically indicate that it's only registrar and the assistant registrar or any other person who is authorized by the state government in that behalf, who is authorized to enter the premises of money lenders to inspect and seize the documents and whether the business is carried out in accordance with the provision of the act or not. The police or inspector, respondent number 2, is not an authorized person in terms of the said act, since no authorization has been placed on record. In that view of the matter, the decision rendered in Sriman's case would be applicable to the present case. General directions. This is not a stray case. There are innumerable number of cases which are coming up before this court where the police officers, though not authorized to exercise any power under the Moneylenders Act, are doing so. In that view of the matter, general direction would have to be issued. General directions. The Director General of Police, State of Karnataka, is directed to issue necessary circulars and or instructions to all the police officers indicating that the police officers do not have any right under the Moneylenders Act to cause a search or seizure under the Moneylenders Act or as regards a complaint filed under the Moneylenders Act. Whenever any complaint is received by the police officer, he should inform the registrar and or the assistant registrar of the said complaint immediately so as to enable the registrar or the assistant registrar of the under the Moneylenders Act to take such action as permissible under law. Lastly, state government has to authorize, not the BJP. It is for the state to consider whether to authorize the police inspectors under the, authorize the police inspector to act under the Moneylenders Act.
In fact, there is Registrar of Moneylenders antane idare.
is there. But 100 people will stand before the police inspector until he takes action.
Yes.
So he is forced to do it.
Please.
It's for the state to authorize the police inspectors under the money line, for to consider the authorization of the police inspectors under the Money Lenders Act. So that these kind of incidents do not happen, since the first port of call for any complainant would be the police station. And it is the complainant who would request and or insist upon the police to take immediate action. And the police inspector takes action on the said complaint, not knowing that he is not authorized, ignoring that he is not authorized to act under the Money Lenders Act 1961. In view of the above, I pass the following order. Criminal petition is allowed. The proceedings in crime number 15 of 2018 raised by the respondent number 1 police now pending before the Chief Metropolitan Magistrate, Ruputanga Road, is hereby quashed. Though the above petition is disposed to report compliance with the general directions released on 2nd April.
Please.
Number 42. Yes, Venkata.
Pass over.
Serial number 43, urgent, 44. Nishant Devi.
I appear for the petitioner minutes.
Mr. Gunjal, ready?
Please minutes.
Pass over.
45, urgent, 46.
Yes.
My name may kindly be shown, my lord. Name of Tamaya may be deleted, my lord, kindly.
Ready?
Number 2.
Ready? Ready.
I'm not.
We'll show your name, no problem in
I'll
showing.
get
your
ready
name.
and I'll argue on the next date, my lord.
Registry that print the name of Shri Suraj Sampath as that appearing for the petitioner and delete the name of Shri Tamaya HN as that appearing for the petitioner at his request, released on 5th March 2024.
In fact, the school where it's supposed to have, the violation is supposed to have occurred has closed down during COVID itself, my lord.
Once the
whether
offense has occurred,
goes
it's
away or not is a different issue, my lord, but
we'll see that.
please,
You want to argue, argue now.
I'll argue on the next date, please.
Serial number 50.
Issue court notice to the petitioner. Court notice to the petitioner. ಯಾರ ಹೆಸರು ಇದೆಯಾ ಬೇರೆ ಯಾರು ಸೈನ್ ಮಾಡಿದ್ರು ಯಾರು ಇಲ್ವಾ ಯಾರು ಬಿಡಲ್ಲ. Issue court notice to the petitioner returnable by 23rd April. Registry is direct delete the name of Shri N. Ravindranath Kamath as that appearing for the petitioner.
51. DK Manjunath.
Yes, for petitioner.
Ready?
Ready.
Where is Mr. Shashidhar?
Date to put. Pass.
Pass over, Badwa.
Madhyana bail on matter.
Though counsel for the petitioner is present and ready to address the argument, none appears for respondent. Released on 5th March.
May I request on 7th or 8th?
7th, 8th,
5th March, my
12th till 13th.
5th I am ready, ma'am.
5th.
Interim order may kindly.
Interim order earlier granted.
The lordship's kind, item number 50, my lord.
Yes.
What has happened, we have sent all the files to Supreme Court. There are 9 litigations. By mistake, this case is also sent, so I was without file. Interim order may be extended.
There is no counsel who has filed Wakalatnama.
Yes, my lord. It has been filed, but
So we'll pass over, file Wakalatnama, then we'll extend.
they are not in station, they are in different.
You should have filed it by now, Mr. Kamath.
I gave the wakalat to one of the colleague, she has left the practice. I did not know that.
So what will you do now, Wakalatnama?
It will be filed in the name of Vanajakshi and Divya Tej.
When?
In 1 week.
Ms. Vanajakshi.
And Divya Tej.
Submit that should be filing Wakalatnama on behalf of the petitioner. Registry is directed print her name once Wakalatnama is filed and delete the name of Shri N. Ravindranath Kamath as that appearing for the petitioner. Relist on 12th March, interim order earlier granted is extended. to next day.
52, B.R. Batraj.
Hearing for petition. Please pass over money, senior.
Pass over.
Serial number 53.
Posed before a bench of which SGRJ is not a party.
54.
I'm sorry,
SKP.
that's the interim order.
Interim order earlier granted is extended. SPP,
Kindly pass. Kindly pass over, madam.
pass over.
55. G.S. Patil.
GS Patil, pass over.
56. Arjun. 57.
Pass over.
9.
Now Arvind from it. There you are. Pass over.
60.
Sorry. Good. This court had accepted. The petitioner is before this court for seeking for the following. This court had accepted the retirement memo filed by the counsel for the petitioner and directed the printing of the name of the petitioner while order dated 4/10/2023. Till date, none has entered appearance for the petitioner, nor is the petitioner present before this court. Hence, it appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
52. Anila TP.
Pass over.
64. Venkatesh Sarbati.
Pass over.
65. Kishore Kumar.
Pass over.
66. Vishwanath N.
Pass over.
68. Hanmantappa P.
Pass over.
70. Narappa K.
Pass over.
71.
71, I am for the respondent, they have not served the copy.
Pass over.
72.
Pass over. 72 allama, 73.
Serial number 73.
Posed before a bench of which SGRJ is not a party.
74. Maya Holder.
74, I appear for the petitioner in a connected matter, my lord, 56703. I pray for 2 days of accommodation, my lord, Monday or Tuesday.
This is Lokayukta, is it?
Please, madam.
Lord, HCGP accepts 74. HCGP accepts notice for respond number 2.
Lord, this matter was.
Who is
heard
for the
in-
petitioner?
I appear for the petitioner.
You are in second matter,
Please, madam.
third matter. Who is
Third
in the first matter?
Maya Holder.
The respondent.
Non-rectification of objection raised on rejoinder filed by. Service agidya?
Ella
Have you
agide,
received?
Swami. Matter was heard in detail, my lord, by the.
No, we are
previous
on the
bench.
first matter.
In both the,
received.
in all 3 matters. Madam. 74. sir.
You are not appearing in the first matter. Have you received the rejoinder? In the first matter, 74?
Rejoinder we haven't received.
We haven't received.
We haven't received.
KMF ಇದೆ ಅವ್ರದ್ದು. ಎಷ್ಟನೇ series ಅದು? 74. ಈಗ ನಡೀತಾ ಇರೋದು.
74.1. You have not filed your MA.
I'll undertake to file notes.
V. Patil undertakes to file his memo of appearance. 74.1. Ms. Vandana PL has entered appearance for the petitioner. Hence memo for retirement filed by Shri Mrinal Shankar is accepted, is discharged from the matter. Ramesh Chandra, you are ready?
My lords, we have ready, my lords. We have even argued once.
Yes.
We are ready.
You filed memo of retirement in 74.2.
Lord, previous council has filed memo of retirement. Lord, I appear for. I have filed my NOC.
Who was the previous council in 74.2?
Mr. Mrinal Shankar has.
In that matter also.
Please.
Shri Mrinal Shankar had earlier appeared for the petitioner. Thereafter, Ms. Vandana PL has now entered appearance, hence memo of retirement filed by Shri Mrinal Shankar is accepted, is discharged from the matter. B. Patil for R2, R3, Wakalat not filed, Ramesh Chandra. You are ready?
We have argued, my lords, on the last date of hearing, this honorable court was pleased to direct the state to take a stand.
Last date, nammunde argument.
Nammundalla, earlier.
ಒಳ್ಳೆ ಕಥೆ ನೀವು.
Not before this. I only meant this.
ಇಲ್ಲ argument ಆಗಿದ್ ಮಾತ್ರ ಹೇಳಿ, ಬೇರೆ ಎಲ್ಲ ಆಗಿದ್ದು ಏನು ಹೇಳ್ಬೇಡಿ.
Allah, it was a part of a
Unless
judicial
we have to
order
send
as
it
such.
there. Patterda ಇದು.
Parted ಏನಿಲ್ಲ. Parted ಆಗಿಲ್ಲ. But after having heard for some time.
So do we send it back to the same
No,
court?
my lords, we'll argue. I have no reservations as such.
Learned counsel for the petitioner seeks, Ms. Vandana PL seeks for 2 days' time to get ready and address argument, released on 5th March.
Please, deeply.
Final hearing, serial number 75. Yogi Swami.
I appear for the.
I have to consult with the tax. Tax advocate, my lord, Mike Canal, government canal.
Michael ಮಾತಾಡಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
In this matter, involved in the tax matter, my lord.
ಹಾ.
Consult with the.
ವಾಣಿ ಅವ್ರು ಬರ್ತಾರಾ?
One year ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. I will consult with them Tuesday, my lord, on 5th or 6th.
5th March. At the request of learned SCGP, though counsel for the petitioner is present and ready to address arguments. You are ready?
No, I'm ready, madam.
At the request of learned SCGP, released on 5th March.
May I submit one submission? He is the counsel earlier to the respondent, my lord.
No, not in this case, madam. I am a government advocate appearing for this tax department, madam, but.
ಅದು ಬೇರೆ. This matter, if he is appeared, then only he is disabled. If he is appeared for somewhere else.
Some other cases, madam. As a government advocate, I am appearing for the department. Then.
In place ಇಲ್ಲಿ ಯಾರೋ ಬಂದಿಲ್ಲ.
ಆಯ್ತು. Fifth, my lord. Yes.
I'll request the.
I'm
Please
sorry,
ask
my
her
lord,
to come.
serial number 74 interim orders may kindly be extended.
74 interim order.
Grateful.
Serial number 36 also. That's small.
Huh?
36, no, serial number 36.
No, pass on ಆಗಿದ್ವಿ.
ಏನಪ್ಪ?
76, 36 ಅಲ್ಲ.
76 ಕರೀಸ್.
Serial number 76.
76.
HK Srivastava.
Paso.
77. Siva Kerala.
Pass on.
Paso.
78, 79 Arjun, 80. Deepak Bia,
Paso.
81.
Paso.
82. MRC Manohar,
Paso.
83. Vaishnavi S. Desai,
Paso.
84. Trivikram S.
Paso.
85 Arjun, 86. Praveen Kumar case and connected matter.
86, my lord, 86.1. I'm for the petitioner.
Ready?
I'm ready. On the other side, my lord.
Paso.
Please.
87. Joseph Anthony, connected matter.
Paso.
88.
Paso.
89 Arjun, 90. Varadraj Havaldar.
Paso. ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಧ್ಯಾಹ್ನ. ಎಷ್ಟು?
91. Monica Patil.
Paso.
92. Raghavendra K.
Paso.
93, Suresh V.
Pass over.
94, S.G. Bhagwan.
My lord, I appear on behalf of Mr. Bhagwan, my lord. I was not feeling well, my lord, yes.
So ಯಾವಾಗ ಬೇಕಂತ?
12th March, my lord.
At the request of counsel for the petitioner, released on 12th March, none appears for the respondent.
Interim order, my kindly.
Interim order earlier granted is extended.
Grateful.
95, Satish Akir.
Pass over.
96, R.B. Deshpande.
For the petitioner, kindly pass over.
Pass over.
97, Harish Kumar Ebbers.
Pass over.
98, Shakuntala Shetty.
Pass over.
99, Rajeshwara PM, unconnected matter.
Pass over.
100, Pradeep S. Saukar.
Pass over. ಮತ್ತೆ ಶುರು ಮಾಡಿ ಪಾಸ್ ಓವರ್.
Pass over matters. Serial number 1.
ಮಾಡಿದಿರೇನಪ್ಪ ಕರೆಕ್ಟ್ ಆಗಿ? Fourth time.
Sorry.
If you don't know, ask any of your seniors, they'll tell you. Okay, ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಯಾರಿಗೂ ಕೇಳಕ್ಕೆ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. Nobody knows everything, but don't keep on committing the mistake.
He just.
Memo of retirement has been filed by the counsel for the petitioner. Dated 27/2/2024, signed by the counsel for the petitioner, enclosing an acknowledgement issued by petition number 2, acknowledging that he's received the entire papers. In that view of the matter, the memo of retirement is accepted. Sri Amrut Chaudhary S. is discharged from the matter. Registry is directed to print the name of the petitioners in the cause list with the endorsement, earlier counsel retired after service of notice. Released on 19th March.
Serial number 8. Abhishek Malipati.
So,
Serial number 16.
230.
28. Jayana Jia.
Yes? Yes. Yes.
28. Jayana Jia.
So,
31. Akti Manjunatha Doda.
I am for that matter in 31.1.
ನೀವಿದ್ದೀರಾ, ಬಾಕಿ ಯಾರು ಬರ್ಲಿಲ್ಲ. ಇನ್ನೊಂದ್ಸತಿ ಪಾಸ್ ಓವರ್ ಮಾಡ.
ಬರಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಮಧ್ಯಾಹ್ನ ಬಂದೇ ಬರ್ತಾರೆ. ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಲಿಸ್ಟ್ ಇದೆ. ಮಧ್ಯಾಹ್ನ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಕ್ಕಿ ಮಂಜುನಾಥ್ ಗೌಡ ಅದು ಡಿಸ್ಮಿಸ್, ನಿಮ್ದು ವಿಲ್ ಅಬ್ಸರ್ವ್ ವಾಟ್ ಇಸ್ ಟು ಬಿ ಡನ್. ಯಾರು ಬರ್ಲಿಲ್ಲ ಮಧ್ಯಾಹ್ನ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಅಷ್ಟೇ.
35.
ಪಾಸ್ ಓವರ್.
36.
ಎಷ್ಟು ತುಂಗಿ?
The offence is under SC/ST Act. Out of the family members of the second respondent, out of the suffered the decree, court decree. Suffered the out of the court decree. Thereafter, out of the filed a trespass case. Now it is my own land. And what may I take to the complaint, not page number 15.
So it happened only in the property, not in the public domain. ಅಷ್ಟೇ.
Yes.
Judgment.
That one, that 2016 part 5, not of the KCC are not there.
2020 Supreme Court, Nagesh Rao. ಅದೇ ಬೇಕಾಯ್ತು. Petitioner is before this court, seeking for the following leaves. respondent number one, respondent number two, complainant up furnished first information on 23/2/2018, in furtherance of which crime number 64 of 2018 was registered by the Nelamangala Rural Police Station on 23/2/2018 at 12:45 PM for offences under punishable under section 447, 504, 506.
That is in-
Read with 34 of the IPC and further read with section 31R, 31S, 31F, 31G of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. The allegation made in the complaint is that the petitioners came to the land of the respondent around 10 AM on 21/2/2018, along with 30%, started installing stone pillars in the said land. And when questioned, they started abusing the respondent, the complainant, and others by mentioning their caste and threatened their life. Shri, challenging the same, the petitioner is before this court.
No, these petitioners were not present, no incident has been happened, and not it is moreover, it is not of the petitioner's law. And they have suffered, not their family suffered the not of the decree, even not the RSA filed by them also.
Lord B. Tumbigi, learned counsel for the petitioner submits that the first petitioner had filed a suit in OS number 85 of 1993 against the second respondent, against the husband of the second respondent, which came to be decreed in favor of the petitioner, and the the husband of the second respondent was directed to execute a raised sale deed, which was finally executed in execution proceedings number 34 of 2009. In further, the same having been challenged in RA 15 of 2001. The decree having been challenged, execution number. In challenge RA number 15 of 2001, the said RA came to be dismissed on 15/1/2005. RSA number 436 of 2013 having been filed by the husband of the second respondent. Even the said RSA came to be dismissed. Thereafter, on an execution petition, execution number 34 of 2009, having been filed, a sale deed came to be executed in favor of the petitioner, and possession was handed over to the petitioner. And it is in that background that the petitioners were putting up stone pillars for fencing the land which had been transferred in favor of the petitioner. It is only as a counterblast to the same that the respondents have filed a complaint. His submission is that even the allegation, if taken to be true, the alleged abuses have been made on a private property between the petitioner and the respondent. There are no other third parties who are present in the place. And in this regard, he relies upon the decision of the Honorable Apex Court in AR 2020 Supreme Court 5584. More particularly, para?
Para number.
18 thereof, which is reproduced hereunder for easy reference. Though respondent have been served, none has entered appearance for respondent number 2. Respondent number 2 has been served, none has entered appearance for respondent number 2. A perusal of the documents which have been produced along with the petition would indicate the submissions made by Ms. Tumgi to be true. The filing of OS number 85 of 1993, and finally resulting in a sale deed being executed in favor of the petition number 1 in execution number 34 of 2009 is borne out by the records. That apart, as rightly contended by Ms. Tumgi, the place of occurrence of the alleged incident, even as if assumed to be true, He is on a private property, and as such, the decision of the Honorable Apex Court in Hitesh Verma's case would apply to the present facts and circumstances. In that view of the matter, I pass the following order. Writ petitions allowed. The first information report in crime number 64 of 2018, pending on the file of the second additional district and session court Bengaluru, is hereby quashed.
Much of.
Interim order itta iduvargu
Yes, my lord, it was there.
is hereby quashed.
38 SPP.
Lord, the
Appa,
interim order
interim
was
order
granted on 27
Atta,
5
Ms. Tumgi, when is the interim order?
27/5/2019.
27/5 illa.
State issued notice not.
Investigation registered shall remain state. Yes.
Thirty-eight.
38, pass over.
40. Hamsa and Raj.
Pass over.
42.
Petitioner is reported dead.
But
in fact, Lord, it was reported before the trial magistrate. Lord, in fact, the trial magistrate sought for a report, my Lord, Lord, I'll 2-3 days time, Lord, what is the status at, my Lord, magistrate court, I'll.
Learned counsel for the petitioner submits that the sole petitioner has expired, which was also reported before the magistrate, who is sought for a report in that regard. He submits that given 10 days time, he would secure the report and make a submission present matter. Relist on 20th March.
Right.
44. Vishal.
Appear for the petitioner, my lords.
Inform Mr. Gunjal. Pass over.
Please.
52.
Pass over.
Respondent number 2 is absent. Some interim order pass agittu.
You asked for pass over saying he'll come.
Yes.
Where is he? Karkond Bani.
Yes.
Respondent number 2 served, so we can take up the matter.
54. SPP.
Please, my lord. Pass out.
Pass over.
55. GS Patil.
Pass over.
57. Raju CN.
Next.
59.
Next.
62.
Next.
64.
Next.
65. 66.
Rita.
8.
Matter 68,
Name
of Rashmi Jadhav may be deleted, a lordship. She's been appointed as the additional SPP. We'll be filing fresh wakalat name of Chetan Jadhav, a lordship. My lords may have the matter next week.
Shri Chetan Jadhav submits that he would be entering appearance for filing wakalatnama for the petitioner. Registry is directed to print his name and delete the name of Ms. Rashmi Jadhav as that appearing for the petitioner. He seeks for and is granted a week's time to get ready and address his arguments. Relist on 12th March.
Great.
70. 71.
ಇನ್ನ ಬಂದಿಲ್ಲ. ಪಾಸು.
ಆತನು ಕೊಟ್ಟಿಲ್ಲ.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಅಷ್ಟೇ.
72.
ಏನು ಇರಲ್ಲ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ. ಹ್ಮ್.
76. 7. 80. 81.
Respond number 2 in this.
Spot number 2. ಇನ್ನ petitioner ಬಂದಿಲ್ಲ.
ಇಲ್ಲ.
ಮಧ್ಯಾಹ್ನ ಡಿಸ್ಮಿಸ್.
82. 83. 84. 86.
For the respondent, number 2 in the connected matter.
ನಿಮ್ಮ petitioner ಬಂದಿದ್ರು ಅವಾಗ್ಲೇ. ಫಸ್ಟ್ ಅಲ್ಲಿ ಯಾರು ಬಂದಿಲ್ಲ. 86.1 ಬಂದಿದ್ರು. ಈಸ್ ರೆಡಿ. ಮಧ್ಯಾಹ್ನ ತಗೊಂಡು.
87. 88. 90.
I'm for the respondent.
Hmm.
In this case.
Respondent ಈ ಕಡೆ.
Petitioner ಇದು ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಹ್ಮ್.
ಆಮೇಲೆ ಜಗಳ ಇವತ್ತಿಗೂ ಕಂಟಿನ್ಯೂ ಇದೆ. ಅದು ಟ್ರಯಲ್ ಅಲ್ಲಿ ನಡೀಲಿ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಡಿಸ್ಮಿಸ್ ದೇ.
ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್.
ಸರಿ ಸ್ವಾಮಿ.
ನೀವ್ ಇದೀರಾ ಅಂತ ನೋಡಿದ್ವಿ ಅಷ್ಟೇ.
91. 92.
Some inconvenience to the petitioner's counsel, instructed counsel, some inconvenience to the instructed counsel, kindly. Interim order.
Request of counsel for the petitioner released on 5th March.
Interim order.
Interim order earlier granted is extended till next date. It's made clear that no further adjournment would be granted if arguments are not advanced. Dismissed.
93.
I am appear for respondent number 2, my lord.
Respondent number 2.
Yes, my lord.
Pass out.
95. 96. 7. 98. 99.
ಅವ್ರ ವೈರಲ್ ಫೀವರ್ ಸೀನಿಯರ್ ರಾಜೇಶ್ವರ್ ಅವ್ರಿಗೆ ಟ್ಯೂಸ್ಡೇಗ ಕೊಳೆ ಹೊತ್ತು ಮಾಡ್ತೀವಿ. ನಾವು ರೆಡಿ ಇದ್ವಿ ಆಕ್ಚುಲಿ. ಇವತ್ತು ಅವ್ರ ವೈರಲ್ ಫೀವರ್ ಆಗಿದೆ. ಟ್ಯೂಸ್ಡೇ ಐ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲರ್ನರ್ ಫ್ರೆಂಡ್ ಹರೀಶ್ ಆಲ್ಸೋ ಮಾಡ್ತೀನಿ.
It's submitted that the arguing counsel is unwell.
Please.
Arguing counsel for the petitioner is unwell. He requests for the matter to be taken up on 5th, released on 5th.
Interim order.
Interim order earlier granted is extended.
Number 100.
For respondent, my lords,
Respondent,
arguing
yes.
counsel, arguing counsel is not keeping well, my lords. Kindly grant them time, my lords.
For the respondent,
Yes, my lords. My lords, interim order may be extended, my lords. Kindly.
none appears for the petitioner. Learned counsel for respondent seeks for a short accommodation on the ground that the arguing counsel is unwell.
Yes, my lord.
Released on, when do you want it?
My lords, any date, my lords, 9th, 8th, possible, my lords.
Released on 12th March. Interim order earlier granted is extended till next time.
Much obliged, my lords.
Serial number 93, I'm respondent number 2. My senior is not feeling well, my lord.
93.
Yes, my lord.
Petitioner ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ dismiss ಆಮೇಲೆ ನೋಡೋಣ. Where are you, madam? 93?
93 matter.
Twice it's been called out. Ready?
No matter time.
The request of counsel for the petitioner released on 5th March. Made clear that no
12th,
further
my lord.
adjournment would be granted.
My lord, 12th, my lord.
12th March.
Sorry, 86.1 ಮೇಡಮ್. ಆಕ್ಚುಲಿ 86 ಕೂಡ ಸೇಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅವ್ರೇನು ಇನ್ನೊಬ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಅವ್ರಿಲ್ಲ ಅವ್ರಿಗಿಂದ ನನ್ಗೆ NOC ಕೊಡ್ತೀನಿ ಇಲ್ಲ, ನಾನು ಇಬ್ರು ಯಾರು ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ ಮಾಡ್ಬೇಕು ಅಂತ
ನೋಡೋಣ.
ಅದಕ್ಕೆ ಒಂದು ಶಾರ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಿದೆ
ಬರ್ಲಿ ಅವ್ರು ಯಾರು ಬರ್ತಾರೋ. ಪೆಟಿಷನರ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಬಿಡಿ.
ನಮ್ ತರ ಪಿಟಿಷನರ್ ಬಂದಿದೆ.
ನಿಮ್ದ್ರಲ್ಲಿ ಇದಾರೆ, ಅದ್ರಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ನೀವು ವಕಾಲತನ ಬೇಕಾಗಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದೆ
ಇರ್ರಿ ಆನಂದ್, ನೋಡೋಣ.
ನಾನು ಓದ್ಕೊಂಡು
ನೀವು ಹೋಗ್ಬೇಕಾ? 80
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಈವನ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಲ್ಲ ಪಾಪ ಅವ್ರಿಗೆ.
ಈಸ್ ಮೈ ನೈಬರ್ ಆಲ್ಸೋ ಇನ್ ದಿ ಆಫೀಸ್.
86.1 ಅಲ್ಲಿ
86.1
ರಾಮಕೃಷ್ಣ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀರಾ?
ಪ್ಲೀಸ್ ಮೇಡಮ್, ಈಸ್ ಮೈ ನೈಬರ್ ಇನ್ ದಿ ಆಫೀಸ್.
ವೆರಿ ಗುಡ್. ಜೊತೆನೇ ಬರ್ಬೇಕಾಯ್ತು.
ಅದು ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡ್ವಿ.
86. ಎಲ್ಲ ನನ್ ಆಫ್ ದೆಮ್ ಸರ್ವೈವ್ ಅನ್ಸುತ್ತೆ. ಎವ್ರಿಥಿಂಗ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಸ್ಮಿಸ್. ಸೊ ಯಾರು ಬರ್ತಾ ಇಲ್ಲ. 86 at the request of Shri K. Ananda, released on
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇ.
12th March.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 4th 5th
5th March.
ಒಬ್ಲೇಸ್
ಆಯ್ತು ಸರ್. ಇನ್ನೆಷ್ಟು ಸತಿ ಕರೆಯೋದು? ಎಸ್. ಹಾ ರೆಡಿ. ಪಾಸ್ ಹೋಗಿ.
Mention, my lord. Serial number, my lord, 90. May I request to withdraw, my lord? Serial number 91, my lord.
91. Petitioner is before this court seeking for the following reliefs. Memo dated 1/3/2024 has been filed signed by the counsel for the petitioner, which reads as under. Accepting the said memo and submission for the counsel, submission of the counsel for the petitioner, petition is dismissed as withdrawn. 87. Yes. Eighty-seven at the request of counsel for the petitioner released on 5th or 12th?
12th, Manoj.
12th March.
There's an IM.
Interim order, IO.
IO.
What have you said? What have you said? Mostly 86.1 ಅಲ್ಲಿ entry ಮಾಡಿರ್ತಾರೆ. Mostly until further present ಆಗಿಲ್ಲ. ಅದು ಇಲ್ಲ ಅಂದ್ರೆ
86.
0.1. ಅವರು ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿ ನಾವು ಮಾಡಿಸಿದ್ವಿ ತಪ್ಪು.
ಈಗ ಅಜ್ಜೇನಲ್ವಾ ಅದು?
ಹ್ಮ್.
ಇದು ನಮ್ಮ ಕತೆ ಯಾರಿಗೆ ಹೇಳ್ದೆ? ಎಲ್ಲಿ ಹೋಗ್ಬೇಕಂತ ಗೊತ್ತಾಗುತ್ತೆ.
ಇಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲ ಇವಾಗ ಇಲ್ವಲ್ಲ ಇಯರ್ ಮಾಡಕ್ಕೆ.
ಅಲ್ಲ ಅದೇ
ಹ್ಮ್
Court officer.
Sir, ಹೇಳಿ sir.
Ah, madam, serial number 87, madam. Serial number 87, madam.
87 urgent 12th March.
Grateful. Thank you, madam. Thank you so much. Thank you.
Court officer.
Court officer? Court officer? Court officer? ಮೇಡಮ್ ಎಲ್ಲಿಗೆ ಬಂತು ಅದೇನೋ ಸಡನ್ ಆಗಿ 99 ಏನೋ ಬಂದ್ಬಿಡ್ತು ಅದಕ್ಕೆ. ಹೌದಾ ನಂದು 84 ಇತ್ತು, ನಾನು ರೆಡಿ ಇದ್ದೆ, ಬಟ್ ಸಡನ್ ಆಗಿ 99 ಬಂತು ಅದಕ್ಕೆ. ಪಾಸ್ ಔಟ್ ಆಗಿದ್ರೆ ನಾನು 2:30 ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ. ಥ್ಯಾಂಕ್ ಯು.
ಅವಾಗೆಲ್ರಿ ಹೊಂಟ್ಯಾರ
Ramaya.
Unless you come and go to what is, I can't understand.
ತುಂಬಾ ದಿವಸ ಆಗಿದೆ ನೋಡ್ಬಿಟ್ಟು. Congratulations on you.
Thank you, thank you.
You are now the president of Dharwad Bar Association.
Yeah, yeah, yeah. Thank you. How are
Congratulations.
you? How are you? Okay, thank you. Thank you. Thank you.
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಲೇಟ್ ಆಗುತ್ತೆ.
ಹೌದಾ? ಎರಡು ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಆದ್ಮೇಲೆ ಪಾಸ್ ಕೋರ್ಸ್. Dharwad bench matters. Serial number 1, Shrikant Patil.
Mr. Bankar. Requested by. The third. The Principal District and Session Judge Dharwad has forwarded a letter of the Principal Civil Judge and Principal JMFC Dharwad, period 19 to 2024, in connection with the forwardal of the documents for examination of the left thumb impression. In the letter, it is stated that the Deputy Director, Regional Forensic Science Laboratory, has informed that the RFSL does not have facility to examine thumb impression, and the documents would have to be forwarded to the Superintendent Fingerprint Bureau, Madiwala, Bangalore. As such, permission is sought for. The permission sought for is granted.
Serial number 2. Seema S. Nayak.
Okay, for sixth respond, my lords.
Yes.
Sixth response.
Further hearing, ಯಾವ್ದು further hearing ಇದು?
Tender matter.
So ಈ ಮ್ಯಾಟರ್ಗೋಸ್ಕರ ಬಂದ್ರಿ ಬೆಂಗಳೂರಿಗೆ. Ms. Seema Nayak. ಎಲ್ಲಿ ಶಿಲ್ವಂತ್?
No, sir. She told that she could not connect the VC. There is some problem. ನಮಗೆ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅವ್ರಿಗೆ.
We'll ask Gurudev to come back to Bangalore once again next week.
We are expecting your lordship, lords. We are expecting your lordships.
We'll not, as well, but we won't ask you. We'll ask Sumangla when date fix ಮಾಡಕ್ಕೆ.
In fact, the matter is also placed before the chief
7th and a long weekend. We'll have it on 7th, Mr. Shilwan.
Please,
And in fact, my lords, the matter is also placed before chief engineer. He is also, my lords, considering as to whether they want to go ahead with this tender or not. 7th, I will make my submission.
Yes. Because there seems to be lapses.
Very true, my lords. They want to go for fresh tenders is what I'm told.
And
but
you have
they
to
are
be
yet
clear on your specification.
Please, please.
ಆಮೇಲೆ ಅದನ್ನ interpretation ಮಾಡೋದಿಲ್ಲ sir.
For commencement of arguments, my lords, I want to make this submission so that
It is submitted that the counsel for the petitioner is unable to connect. Hence relist on 7th at 2:30.
great.
please.
Customer matters. Serial number
I've
8.
got the records also, my lords. I'll place it on the other.
You carry it on that day.
Serial number 8.
Mr. Vasant. Though counsel for the present petitioner is present, none appears for respondent number 2, though called thrice, twice in the morning session and once in the afternoon session. If none were to appear for the respondent on the next date of hearing, so you don't even have the statement of objections. If none were to appear for the respondent on the next date, respondent number 2 on the next date of hearing, the statement and the compliance not made, the statement of objections will be struck off and the matter would be taken up for consideration on the basis of the submission made by counsel for the petitioner. Relist on 12th, 15th March.
Please. Serial number 16. PM Halaswamy.
Yes. Yes, what is this?
Kindly see the first document, my lord, the petitioner, my lord, is the owner.
That's why mic ಆ ಕಡೆ ಹೋಯ್ತು.
And the two sale deeds, he had purchased the property, my lord, both put together, my lord, it's a 17/3, my lord, 3 acres, 10 guntas, my lord. Kindly see page, my lord, 11, my lord. There is no karab, my lord, even the.
Page 11 of the petition and in documents, sir.
11 of the petition, my lord.
Petition.
Now, what I have purchased under two sale deeds, my lord. That
This
is put
is 17
bar 3, kindly see, ISA 3.
bar 3.
3 acres, 10 guntas, my lord. There is no Karab. Because in rest of the lands which I have produced, my lord, there is a port Karab which was reserved for road, that's car track, my lord. In
Yes.
survey number 15 and others, my lord. Next RTCs which I have produced, my lord. In respect of the petitioner's land, my lord, there is no Karab, my lord. What happened, my lord? Because they tried to form, because there are a road, my lord, he filed a suit, my lord. Kindly see the judgment. I will come to page 18, my lord. This is a suit wherein, my lord, suit was filed against the Deputy Commissioner, Jilla Panchayat, the government, PWD, and all those things, my lord. Now, kindly see page 27, my lord. The court holds that, my lord, at some after 2-3 lines in the first paragraph, my lord, that plaintiff and owner of, hence the evidence of the plaintiff and the documents are in consonance with the plain government, and accordingly has successfully established this title and possession over the suitable property. Hence I answer. Now, coming to the next paragraph at 10, my lord.
What is issue number 1?
Issue number 1, my lord, whether is the owner, my lord.
Where is it?
Plaintiff is the owner in possession of land, survey number 17 bar 1P, by that time, my lord, kindly see, my lord.
Yes.
17 bar 1P and 17 bar 1.
3 acres, 18 guntas.
18 guntas, that was some lands maybe, my lord, now it reduced to 3 acres, 10 guntas, my lord. Now, at paragraph 10, my lord, according to the plaintiff, without any acquisition of any portion of the in the suit land, the defendants are illegally and high-handedly forming new road by diverting from old car track. Now, kindly see, my lord, this was one track, car track, which was in the other survey number 15, 16, and the remaining portion of the 17, my lord, not in my land, my lord.
It is existing in 15 and 16.
16, and as there's a car track just edged, even in 17, my lord, not in 17 bar 3, my lord. I will refer to the sketch, my lord. As per the plaintiff, there is a car track just edged to his suit property and for about 100 feet in length, and the said road passes through survey number 14 to 16 as per village map. Without any acquisition or any portion of the land in suit property, the defendants are influential, who are highly influential as a official capacity, they are informing the road, so on, so, my lord. Now, kindly see the judgment, my lord, the court decreased my suit, my lord. Injunction was refused, my lord. The court holds that I am in possession of the property.
Abutting the land passing on the southern side.
The suit of the plaintiff is hereby partly decreed. Further, it is ordered.
They are saying that the road is situated abutting your land.
Abutting.
And they are repairing the land. They are
My
repairing
lord.
the road.
That, my lord. I will
Situated
refer to the
outside your
sketch, my
land.
lord. It is abutting my land, my lord. Not it was not in my land, my lord. That's at that time it was stated, my lord. Even after survey, they have, after I filed an execution petition, my lord. In the I filed because the injunction was refused, my lord. I filed an appeal, my lord. Then they admit that they will form the road as per the sketch,
In
my lord.
para 13, they say is deposit, they are improving the old road which is existing in survey number 17.
Existing in
Not forming new road.
They say, my lord. They say, my lord, there is a road which was there, they are trying, but there is only one road because of that encroachment made by in the survey number 15 and 16, my lord. They were trying to use in my property, my lord. Kindly see, my lord, what they admit in the RA, my lord. They admit that they will form the road as per the sketch, my lord, which was not done. And in 2004, the decree, my lord. 2005, my lord, there is in the RA, my lord, which was got compromised at page. Now, kindly see page 41 schedule, my lord. Schedule 117 in irrigate second property, my lord. In 17, in both the east and west, 17 survey number 17 is there in my property, my lord, at item number 2, my lord, page 41. Kindly see east, my lord, survey number 17 is there, west survey number 17 is there. In the middle, my lord, my land is there 17. This is what which was formed into 17 bar 3, my lord. Road passes through 17 bar 4, my lord. That is on the western side, my lord. Now,
see, this makes it 22 guntas plus the 2 acres, 36 guntas. And 3 acres, 18 guntas.
3 acres, 18 guntas, my lord. For some
gunta elinda bantu. Extra. 8 guntas ಎಲ್ಲಿಂದ ಬಂತು?
3 acres, 18 guntas, my lord, whether it was, but anyhow, my claim is lesser, 3 acres, 10 guntas only, my lord.
But this whole thing is about, so where that if the road is being formed in 8 guntas, you can't have any claim against that.
No, I will refer to my, lord. Not in 8 guntas, that is where, my lord, it doesn't come in this land itself, my lord, I will come to that, my lord. No, because in that appeal, my lord, kindly see, they will form as per exhibit P6, that's a village map, my lord. They agreed, my lord, in RA, my lord.
Yes.
Because they did not, because there was the department ZP wanted to form a road, my lord. By that time, this writ petition, kindly see, my lord, the other owners who had encroached this portion of the land, my lord, are page 62.
So where is this exhibit P6?
Exhibit P6, my lord, in this, not there, my lord.
Because you agree, you had no objection for
To form the road as per exhibit
as per
P6.
exhibit P6.
As per exhibit P6, my lord.
So where is exhibit P6?
Exhibit P6, it's not in, you know, it is a road, it's, now it is, they are formed as per exhibit P6, my lord, as at page 97, my lord. They refer, my lord,
87 is exhibit P6.
97, my lord, page 90, because I filed an application before the executing court to form, not to contravene the compromise decree, my lord. Direction is issued to the Jilla Panchayat, my lord, and the internal correspondence at page 94, my lord.
P7 exhibit P6 ಅಂತ ಎಲ್ಲೂ ಬರ್ದಿಲ್ಲ.
ಅಲ್ಲ, ಇದು exhibit P6 ಅಲ್ಲ, ಅದ್ರ ಪ್ರಕಾರ ಇವ್ರು ರೋಡ್ ಮಾಡಿದ್ದಾರೆ.
P6 ಅಲ್ಲಿ.
P6, it's not in, like.
So if they formed as per exhibit P6,
Exhibit
you
P6.
cannot go and remove the road.
Pardon me?
If they have formed it as per exhibit P6, you cannot go and remove the road.
No, I have not removed the road, my lord. I will convince that, my lord. What happened, my lord? Because some other persons had come up before this court, my lord. Then order was passed by this court, my lord, in that some observation, but if there is an existing road, you proceed with that, my lord. By that time, my lord, now the ZP, they wanted to form a new road in my land, my lord.
Let investigation happen. This is at the FIR stage.
Allah, they have formed the road. Now it is not, kindly see, my lord, it's my personal property. I-handedly.
Can we give a finding at this stage on that, Mr. Alaso? We go into all, there's so many disputed questions.
My lord, now they have formed a road. Now they, according to the ZP, my lord, they have formed a road, my lord, as per the village map, my lord.
And they are going to withdraw the complaint.
But
They
the
withdraw the
allegation,
complaint.
they have to ask for the
There is
compensation,
no,
anything.
kindly see, my lord, even there is
Without
no-
remove,
They are withdrawing the complaint, then nothing will remain.
It was,
If they have formed the road and there's nothing will survive, it is for them to say, are you withdrawing the complaint?
they agree, their road, they make, if we are ready to give up the matter, the dig the road without knowledge, matter.
ಅವ್ರು ಹೇಳ್ತಾರೆ ನೀವು ರೋಡ್ ಬೇರೆ ಕಡೆ ಮಾಡಿದೀರಾ,
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಇದೆ.
ಅಲ್ಲಿ ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವರು ನಾವು ಬೇರೆ ಅವ್ರ ಮೇನ್ ರೋಡ್ ಬಿಟ್ಟು ನಮ್ ಜಮೀನಲ್ಲಿ ರೋಡ್ ಮಾಡಿದಾರೆ ಅಂತ ಅವರು ಅಲಿಗೇಷನ್. But as per map, we are formed it. If it is disputed, he can dispute it. Why dig the road up?
The allegation is
Allah,
that,
2 documents I will refer to, my lord, whether.
the allegation is that you have removed the road which has been.
Even there is no
laid.
material in the charge sheet, my lord, kindly. What
Where is the
happened?
charge sheet?
Charge sheet ಅಲ್ಲಿ ಏನು, because I obstructed to form, once again to form the bigger
not
road in my
obstruct.
land, my lord. That was the only thing, my lord. What the cyclostyle statements from the 3-4 persons, my lord.
Charge sheet you have put.
Allah, now kindly see page 95, my lord. This shows how they formed the road. They have left my property and they formed the road, my lord. It doesn't come within the meaning of the public, my lord, the damage to the, when they have I-handedly formed the road in my land, my
These
lord.
are not matters that we can decide in 482, Mr. Alaswamy. The petitioner is before this court seeking for the following reliefs. The petitioner claims to be the illu 3 acres 18 guntas ಅಂತ ಹೇಳಿದೀರಾ. RTC 3 acres 10 guntas ಇದೆ. You are claiming more than what you have. Claims to be the absolute owner in possession of land bearing survey number 17/3, measuring 3 acres 18 guntas, situated at Kunibelekere village, Harihar Taluk, Davangere district. It is contended said land was earlier comprised in survey number 17/1P1 measuring 2 acres 26 guntas and survey number 17/1P3 measuring 23 guntas. Ad nodre 3 acres 19 guntas ಆಯ್ತು. Totally measuring 3 acres 18 guntas. Wrongly calculated, bracket close.
Maybe wrongly.
A cart track leading from the petitioner contends that a cart track from Kunibela Kerry village to main road runs in survey number 16, survey number 15, 14, and 17/4 of the said village. And there's no such cart track passing through survey number 17/4, 17/3. The petitioner had filed a suit in OS number 323 of 2022 seeking for declaration of ownership in respect of survey number 17/3 and an injunction restraining the Deputy Commissioner and the Public Works Department from interfering with the possession of the petitioner. Though declaration relief was granted, injunctive relief was refused, which was challenged in RA number 20 of 2004, where a compromise was entered into, under which the petitioner agreed that a road could be formed in terms of Exhibit P6 thereto. And as such, a compromise decree was drawn up. Is thereafter alleged that the respondent number 2 had lodged a complaint in crime number, which the first information which came to be registered as crime number 20 of 2014 by the Yav Police, by the Malebennur Police Station, Harihara Taluk, alleging that the petitioner had removed a portion of the road which had been formed in terms of Exhibit P6. And as such, loss of rupees 5 lakhs had been caused to the state. And in that background, the FIR and crime number 20 came to be registered. Upon investigation, a charge sheet has been laid on 27/8/2014 in crime number 20 of 2014. Alleging that the road has been unauthorizedly removed by the petitioner. And as regards the same, there have been statements of witnesses which have been recorded. It's challenging the registration of the FIR and charge sheet that the petitioner is before this court. The Alaswamy Learned Counsel for the petitioner would submit that there is no road which is running in survey number 17, and that the petitioner has not removed any road which has been laid by the respondents. Thus, the allegation made by the respondent is completely false. His submission is also that the road has not been laid in the land of the petitioner, but has been laid in the adjoining land.
No, my entire case is, my lord, they wanted to, my land.
ಇವಾಗ ಹೇಳಿದ್ದು ನೀವು ರೋಡ್ ಬೇರೆ ಕಡೆ ಮಾಡಿದ್ದಾರೆ ಅಂತೆಲ್ಲ ಹೇಳಿ.
ಬೇರೆ ಕಡೆ ರೋಡ್ ಮಾಡಿದ್ದಾರೆ. Because my land, my lord, it is not a public property, my lord. They instead of
ಇವಾಗ ಮಾಡಿದ್ದಾರೆ ಅಂತಾನೆ ನೀವು
they have formed the other road, my lord.
A road has been formed outside the
Outside,
property
in the other survey
of the property of the petitioner. And the question of the petitioner removing any road allegedly formed in the land of the petitioner would not arise. A perusal of the documents produced along with the charge sheet, including the statements, indicates that a statement of witnesses indicates that the categorical statement made that on 26/1/2014 at 10 AM, to 26/1/2014, commencing from 10 AM, the petitioner started removing the road, which went on till 7 AM on 27/1/2014. Whether the road exists in the land of the petitioner or outside the land of the petitioner, whether the road was laid in the land of the petitioner or outside, whether the respondent has a right to lay such a road or not, are not matters which could be considered in a petition under section 482. Be that as it may, these defenses on part of the petitioner would have to be established during the course of trial in the pending proceedings. At this stage, it cannot be said that there is no offense made out against the petitioner requiring this court to intercede by exercising powers under section 482 of the CRPC. Thus, no grounds having been made out for such exercise of power. The petition stands dismissed. Liberty is reserved to the petitioner to agitate all defenses before the trial court.
Serial number 28. Jayana GR.
None appears, though called twice in the morning session and once in the afternoon session. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
31.
31 Ajay mentioned. 31.
31.1, my lords.
31.
0.1.
None appears for the petitioner, though called. Yes, Sati Kari Battery. Ready na? Where is Naveed Ahmed? None appears for respond number 2 in criminal petition number 1751 of 2018. If none were to appear for respond number 2 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by the counsels for the petitioner. Released on 5th March.
35.
Much of it.
35. Same, none appears, though called twice in the morning, once in the afternoon, dismissed for non-prosecution.
38.
Yes, ಏನಾಯ್ತು ಹ್ಯಾಂಡ್ ಓವರ್ ಆಗಿದೆಯಾ ಏನಾಯ್ತು?
They filed the petition, my lord. For custody of the
Accused number 1.
accused number 1. That was rejected, my lord.
ಏನಾಯ್ತು ಅದು ಕ್ರೈಮ್ ನಂಬರ್ 196?
ಅದಕ್ಕೆ ಈಗ ಏನಾದ್ರು ಆಗಿದೆ ಅಂತ ಮುಗ್ದೋಗಿರ್ಬೇಕು ಅನ್ಸುತ್ತೆ ಸರ್.
ಅದೇ ಬೆಳಿಗ್ಗೆ ಅದೇ ಹೇಳಿದ್ರೆ ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
ಹೇಳಿದೀನಿ ಕೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇವಾಗೇನು ಪಾಸ್ ಓವರ್ ಮಾಡೋದ ಅರ್ಜೆಂಟ್ ಮಾಡಿ.
Fifth, my lord.
Fifth. Then SCGP 6 bond is granted 2 days time to ascertain the status of the proceedings in crime number 196 of 2017. Relist on 5th.
Please.
40. Same, twice in the morning, once in the afternoon, dismissed.
44.
Yeah, for the petitioner.
Where is Mr. Gunja? You informed him?
No, my lords, he may not come because after the complaint, my lords, the matter has resulted in a sale deed and complaint may not be maintainable.
ಅದಕ್ಕೆ ನೀವು ಕರೀರಿ ಅಂತ ಹೇಳಿದ್ದು ಅವ್ರಿಗೆ. You can call him, he will come.
Please, my lords,
Will he not come?
please.
Relist on 5th for appearance of counsel for respond number 2.
Interim order granted.
Interim order earlier granted.
Great.
So we'll record his statement and close the matter.
Please.
52.
Yes. Yes.
Please. Offenses under sections, my lord. 420, 504, 506, and 34 of IPC, my lord. So that the charge sheet has been filed and the same is pending before the additional JMFC, Anekal, my lord.
The petitioner is the accused number 3, my lord.
Hmm.
The allegation against the petitioner, my lord, is the witness under the agreement to sell, my lord. Witness under the sale agreement dated 3/5/2013, my lord, entered into between the accused number 1 and 2, my lord. Sorry, accused number 1 and 2 and the petitioner complainant, my lord. That is the second respondent.
Hmm.
So it is not in dispute, my lord. As per the sale agreement, the second respondent filed the suit in OS number 595/2016, which has been filed on 16/6/2016, my lord, and the same has been decreed on 1/1/2018, my lord. Based on the sale agreement, my lord, the judgment copy is also produced along with the petition, my lord. The same is at page number 40, annexure F, my lord. The sale agreement is also produced, my lord.
The occurrence of the event is when?
But according to the complaint, my lord, on 3/5/2013, there is agreement.
This incident of the allegation against, where is the complaint?
My lord, page number 23, my lord. 24, my lord.
Read the complaint.
Please, my lord. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ಪೇಜ್ ನಂಬರ್ 24, my lord. ಟೈಪ್. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ಆನೇಕಲ್ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ತಟ್ಟನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 198ರಲ್ಲಿನ 38 ಗುಂಟೆ ಜಮೀನನ್ನು ಅತ್ತಿಬೆಲೆ ಟೌನ್ ಅಂಚೆ ಕಚೇರಿ ಬೀದಿ ಬೊಡ್ಡೂರು ರಾಮಯ್ಯನವರ ಮಗನಾದ ಆರ್ ನಾಗರಾಜು ಎಂಬುವವರಿಂದ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಪಡೆಯಲು ಮಾತುಕತೆ ಮಾಡಿ ದಿನಾಂಕ 30/5/2013 ನನ್ನ ಹೆಸರಿಗೆ ಕ್ರಯದ ಕರಾರು ಪತ್ರ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ಇದರಿಂದ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ಸೇಲ್ ಪರ್ಮಿಷನ್ ದಾಖಲೆ ಕೇಳಿದಾಗ ವಕೀಲರ ಬಳಿ ಇದೆ, ಅದನ್ನು ತಂದು ನಿಮಗೆ ತೋರಿಸಿ ನಂತರ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿಯಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ಆದರೆ ಸೇಲ್ ಪರ್ಮಿಷನ್ ಮಾಡಿಸಿಕೊಡಲಿಲ್ಲ. ಆಗ ನಾನು ಕೊಟ್ಟರು ಅಡ್ವಾನ್ಸ್ ಹಣ ವಾಪಸ್ಸು ಕೊಡಿ ಎಂದು ಕೇಳಿದಾಗ ಇದು ಒರಿಜಿನಲ್ ಜಮೀನು, ಮಂಜೂರುದಾರರಾದ ಗ್ರಾಂಟ್ದಾರರು ಮುನಿಯಪ್ಪ ಎಂಬುವವರ ಕಡೆಯಿಂದ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ಮಾಡಿಸಿ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಮೂಲ ಮಂಜೂರಿದಾರರಾದ ವೈ ಮುನಿಯಪ್ಪ ಸನ್ ಆಫ್ ಲೇಟ್ ಯಲ್ಲಪ್ಪ ತಟ್ಟನಹಳ್ಳಿ ವಾಸಿ ಎಂಬುವರ ಕಡೆಯಿಂದಲೇ ನಿಮಗೆ ಜಮೀನು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡುತ್ತೇನೆಂದು ದಿನಾಂಕ 27/7/2013 ವೈ ಮುನಿಯಪ್ಪರವರು ನನ್ನ ಹೆಸರಿಗೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ಟರು. ಇದಕ್ಕೆ ಸಾಕ್ಷಿಗಳಾಗಿ ನಾಗರಾಜು ಸಹ ಸಹಿ ಹಾಕಿರುತ್ತಾರೆ. ವೈ ಮುನಿಯಪ್ಪ ಮತ್ತು ನಾಗರಾಜುರವರು ನನಗೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ಟು ಇದುವರೆಗೂ ಯಾವುದೇ ದಾಖಲೆಗಳು ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನನಗೆ ಜಮೀನನ್ನು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡದೆ ಚಂದಾಪುರ ವಾಸಿ ಎಂ ಮಹೇಶ್ ಸನ್ ಆಫ್ ನಾಗರಾಜ್ ಎಂಬುವರ ಹೆಸರಿಗೆ 5/11/2014 ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ನಾನು ಈ ಬಗ್ಗೆ ಮುನಿಯಪ್ಪ ಮತ್ತು ನಾಗರಾಜರವರ ಬಳಿ ಹಾಗೂ ಮಾತುಕತೆಗೆ ಮಧ್ಯವರ್ತಿಗಳಾದ ಮುರಳಿ ರವರ ಬಳಿ ಕೇಳಿದಾಗ ಅವರುಗಳು ನನಗೆ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ನಿನಗೆ ಎಷ್ಟು ಹಣ ಕೊಡಬೇಕೋ ಅಷ್ಟು ಹಣವನ್ನು ವಾಪಸ್ ನಿನ್ನ ಹಣ ಕೊಡುತ್ತೇವೆ, ಜಮೀನು ಬಳಿ ಬಂದರೆ ಸುಮ್ಮನೆ ಬಿಡುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಪ್ರಾಣ ಬೆದರಿಕೆ ಸಹ ಹಾಕಿದ್ದರು. ಸದರಿ ಅವರು ಜಮೀನನ್ನು ನನಗೆ ನೀಡಬೇಕೆಂದು ಹೇಳಿ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ಟು ನಂತರ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಜಮೀನು ನೀಡದೆ ಇವರಿಗೆ ಅವರಿಗೆ ನನ್ನ ಮಾರಾಟ ಮಾಡಿ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಜಮೀನು ನೀಡದೆ ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಕೇಳಲು ಹೋದಾಗ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿದ ಸ್ವಯಂಸು. That is the allegation, my lord. But with respect to the civil disputes concern, my lord, the second respondent already.
It has been laid. What does the charge sheet say?
Please. My lord, the charge sheet, my lord, is at page number
28.
Please, my lord. The relevant, my lord. Page number 28. ಆನೇಕಲ್ ತಾಲೂಕು ಅತ್ತಿಬೆಲೆ ಹೋಬಳಿ ಎಡವನಹಳ್ಳಿ ಗ್ರಾಮದ ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಕಾಲಂ ನಂಬರ್ 2ರಲ್ಲಿ ಕಂಡ ಆರೋಪಿಗಳ ಪೈಕಿ ಎರಡನೇ ಆರೋಪಿಯು ತಟ್ಟನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 198/2ರಲ್ಲಿನ 38 ಗುಂಟೆ ಜಮೀನು ದಿನಾಂಕ 30/5/2013 ಸಾಕ್ಷಿ 1ರವರಿಗೆ 68,25,000 ರೂಗಳಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಮಾತುಕತೆಯಂತೆ ಮುಂಗಡವಾಗಿ 25,25,000 ಹಣ ಪಡೆದುಕೊಂಡು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದು ಉಳಿಕೆ ಹಣ ಕ್ರಯದ ಪತ್ರ ಮಾಡುವ ಸಮಯದಲ್ಲಿ ನೀಡುವುದಾಗಿ ಸಾಕ್ಷಿ 1ರವರು ತಿಳಿಸಿದಾಗ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ಸೇಲ್ ಪರ್ಮಿಷನ್ ದಾಖಲೆ ನೀಡುವಂತೆ ಕೇಳಿದಾಗ ವಕೀಲರ ಬಳಿ ಇದೆ ಎಂದು ಸಬೂಬು ಹೇಳಿ ಸದರಿ ಜಮೀನು ಗ್ರಾಂಟ್ ಜಮೀನು ಆಗಿದ್ದರಿಂದ ವಾಪಸ್ ಅಡ್ವಾನ್ಸ್ ಹಣ ಕೊಡುವಂತೆ ಸಾಕ್ಷಿ 1ರವರು ಕೇಳಿದಾಗ ಮೂಲ ಮಂಜೂರಿದಾರರಾದ ಎರಡನೇ ಆರೋಪಿ ಮುಖಾಂತರ ದಿನಾಂಕ 27/7/2013 ಮತ್ತೊಂದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ಅದೇ ದಿನ GPS ಸಹ ಮಾಡಿಕೊಟ್ಟಿದ್ದು ಸ್ವಲ್ಪ ದಿನದ ನಂತರ ಸಾಕ್ಷಿ 1ರವರು ಜಮೀನು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡುವಂತೆ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳ ಬಳಿ ಕೇಳಿದಾಗ ಇದುವರೆಗೂ ಯಾವುದೇ ದಾಖಲಾತಿ ಸಿದ್ಧವಾಗಿಲ್ಲವೆಂದು ಸುಳ್ಳು ಹೇಳಿ 3ನೇ ಆರೋಪಿ ಜೊತೆ ಸೇರಿಕೊಂಡು ದಿನಾಂಕ 5/11/2014 ಚಂದಾಪುರ ವಾಸಿ ಎನ್ ಮಹೇಶ್ ಎಂಬುವರಿಗೆ GPA ಮಾಡಿಕೊಟ್ಟಿದ್ದು ಈ ವಿಚಾರದ ತಿಳಿದು ಆರೋಪಿಗಳ ಬಳಿ ಕೇಳಿದಾಗ ಆರೋಪಿಗಳು ಸಾಕ್ಷಿ 1 ರವರನ್ನು ಕುರಿತು ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ನಿನಗೆ ಎಷ್ಟು ದುಡ್ಡು ಬೇಕು ಹೇಳು, ದಿನ ಹಣ ವಾಪಸ್ಸು ಕೊಡುತ್ತೇವೆ ಎಂದು ಹೇಳಿ ಅಡ್ವಾನ್ಸ್ ಹಣ ವಾಪಸ್ಸು ಕೊಡದೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಜಮೀನಿನ ಬಳಿ ಬಂದರೆ ನಿನ್ನನ್ನು ಸುಮ್ಮನೆ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆಂದು ದೃಢಪಟ್ಟಿರುತ್ತೆ. My lord, admittedly, the sale agreement has been executed by one Shri Muniappa. That is accused number 2 and 3, accused number 1 and 2 in favor of the second respondent. My lord. Based on which, my lord, the already civil suit has been filed and the same is already decreed in favor of the second respondent. My lord.
So suit was filed in 595
Finally,
and decreed.
Decreed, my lord. It is at page number 40, my lord. Annexure F.
Sale deed ಆಗಿದೆಯಾ?
But decree ಆಗಿದೆ. Decree is against accused number 1 and 2, my lord.
Complainant favor ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ?
Certain, my lord, because
ಏನಾಯ್ತು ಆ ಡಿಕ್ರಿ?
suit has been decreed.
1/1/2018.
Please.
That only establishes that there was a valid agreement.
We are not.
You had no business.
We are
to
not
use
disputing
Awachi.
the agreement, my lord. We are just witness, my lord. He is the mediator and the witness, my lord.
Yeah,
We have not
but-
executed any sale agreement or anything, my lord. Even though I am not the owner of the property also, my lord.
But you're in the background.
No, my lord, please, just he is the witness under the agreement, my lord.
ಇರತ್ತೆ ಬಟ್ ಏನು?
My lord, suit has already been decreed, my lord.
You are escaping from it now.
Suit has already been decreed, my lord. Just he is the witness under the agreement.
Before this court seeking for the following relief.
My lord, page number is just
The complainant respond number 2.
otherwise I will
The
record.
first information on 36/2015 with the Atibele police station alleging that the petitioner along with certain other accused had abused the petitioner, abused the complainant and threatened him with life when the complainant had approached them inquiring about the execution of sale deed in furtherance of agreement dated
27/7/2013.
And that accused number 1 and 2 being the owners, along with certain others, had executed a general power of attorney in favor of one Mr. Mahadev and had intended to sell the property to a third party, depriving the complainant of his rights under the agreement of sale. Investigation having completed, a charge sheet has been laid on
23/8/2015, my lord.
23/8/2015, when the allegation against the petitioner and certain other accused has been reiterated. Is challenging the same, the petitioner is before this court. Learned counsel for the petitioner submit that the dispute between the petitioner, between accused number 1 and 2 and respondent number 2 complainant is civil in nature, inasmuch as an agreement of sale was entered into by accused number 1 and 2 as vendors in favor of respondent number 2 as a purchaser. The purchaser having filed a suit in OS number 595 of 2016, specific performance has been granted under a decree dated 1/1/2018. Thus, he submits that the entire disputes between is civil in nature, which has been given a criminal twist. Insofar as accused number 3 is concerned, he submits that he was only a witness to the power of attorney.
To the agreement to sale, to the agreement to sale of the second
Sale.
respondent.
And he has nothing to do with the further power of attorney or agreement entered into by accused number 1 and 2 with third parties. Respondent number 2, though served, has remained unrepresented. A perusal of the papers would indicate that indeed a agreement of sale dated 27/7/2013 has been executed by accused number 1 and 2 in favor of respondent number 2 complainant. And in the suit filed in OS number 595 of 2016, a relief of specific performance has been granted. The only allegation against the petitioner in the present case is that he was a witness to the agreement of sale dated 27/7/2013, and that at his instance, respondent number 2 had entered into an agreement of sale. The factum of entering into an agreement of sale on 27/7/2013 has nothing to do with the subsequent event of accused number 1 executing a general power of attorney in favor of third person Mahadev and wanting to execute a sale deed in respect to third party, as regards which the petitioner is not a part thereof, nor has the petitioner signed any documents. The only transaction which the petitioner was involved in was the agreement of sale dated 27/7/2013, as regards which OS number 595 of 2016 has been filed, where a decree of specific performance has been granted on 1/1/2018. Thus, I am of the considered opinion that there is no element of criminal offense which has been made out against the petitioner requiring the proceedings to go on. Hence, I pass the following order. Petition is allowed in part, the criminal proceedings in CC number 1191 of 2016, pending on the file of the principal civil judge in JMC Anikal, is quashed insofar as petition number 1, who is accused number 3, therein is concerned.
Grateful.
The proceedings in respect to the other accused, where as regards the allegations made against them, would continue.
Great.
Serial number 54, SPP
64.
64.
That's currently on my sixth mark, my lord. Because I have to discuss with the.
At the request of learned SCGP released on 6th March.
55. DS party.
Price morning, dismiss.
57.
Same order. Same order.
59.
Same order. Same order.
64.
I'm appearing for the petition.
Yes.
Very short time.
At the request of counsel for the petitioner released on 5th March, if arguments are not advanced on that date, petition will be liable to be dismissed for non-prosecution.
Interim order.
Interim order. 65.
Kishore Kumar.
Same dismiss.
66.
Dismiss.
70.
No counsel for respondent is present. None appears so and so. Dismissed.
71.
For respond.
Same. Though counsel for respondent present. And he submits that even a copy of the petition has not been furnished to the respondent. None appears. Size dismissed.
72.
72. Same dismiss.
76. 77.
Where's Mr. Rajshekhar? Though counsel for the petitioner has been present whenever the matter is called out, none has appeared for respondent, though called twice in the morning session and once in the afternoon session. If none were to appear for respond number 2 on the next date of hearing, the matter would be taken up for consideration.
Please.
On the basis of submission made by the counsel for the petitioner, released on 12th March.
Please. Interim order earlier granted.
Interim order earlier granted is extended till next.
Grateful.
18. Deepak, we are.
81, my lord, sir. I'm there in 81.
Not at called, Mr. Joshua. 80, Mr. Deepak. None appears, thrice dismiss.
81.
My lords, I appear for the petitioner.
Yes. Yes, please.
My lords, this is a matter wherein the complainant had lodged a complaint on the basis that after he had obtained a sale deed in respect to the property, which was the subject matter of a civil suit, my lords, I had entered into an agreement. Under that particular agreement, I had received a sum of rupees 1 lakh. Subsequently, my lords, what had happened is he had filed a suit. Court directed me to refund the amount of rupees 1 lakh. Along with the sum of rupees 2 lakhs, my lords, I have deposited in court. Today, the memo which I have filed, my lords, which is a part of the records, my lords. That is on 27th February 2018.
Where is
And I have
that
also
order?
given it to the police. The
Where is that
complainant
order?
is a subsequent. Sorry, my lords.
Where is the order passed in the suit?
My
Judgment.
lords, that is been produced here, my lords, at Annexure E. It starts at Annexure
Page
E,
number.
page number 33, and it is at page number 51, my lords, the relevant. The suit of the plaintiff. Has my lord got it?
Srinivas Murthy. This is filed by Srinivas Murthy.
Srinivas Murthy, my lords. What had happened is he is the agreement holder. The complainant is a subsequent purchaser.
You are the owner of the property.
I was the owner of the property, my lords.
Yes. Who is Srinivas Murthy?
Srinivas Murthy is my agreement holder from whom I had received 1 lakh.
When was the agreement entered into?
My lords, the agreement was entered into, my lords, in the year 22/5/2004.
Yes.
Subsequent. Sorry, my lords.
Complainant? What about the
Complainant is a subsequent purchaser of the same property.
from you?
Yes.
Yes, my lords.
So he is not you are the person who has sold it to twice.
No, my lords. I'm sorry, my lords. I'll stand corrected there. Subsequently, I had sold it to somebody else, and that somebody had sold it to the complainant. Complainant, once he got to know about this particular suit.
Who did you sell it to?
My lords,
Who did you sell it to?
those details I have not produced, my lords, because he had filed. Those details are not there on record, my lords. But the fact of the matter remains. Pursuant to this particular judgment and decree, I have deposited 2 lakhs before the court, and that has been accepted. And his title also has been confirmed.
That is in respect of Srinivas. That is for Srinivas Murthy, Mr. Joshua.
My lords, that is in respect of Srinivas
How does that
Murthy.
help against the?
Because there is no that.
Yes.
His main grievance was you had entered into an agreement earlier, and as per the terms of the agreement, there is a suit for specific performance. My title will get affected because I am the subsequent purchaser from another person. Now, my lords, by virtue of the fact I have paid this.
What made you execute 2 agreements for the same property?
No, my lords, I'll
in
just
favor of
explain,
2
my lords.
different people?
No, my lords, I'll just explain, my lords. What had happened is that I had contracted with Srinivas Murthy. Srinivas Murthy never came forward in order to execute, in order to pay the balance amount and take the sale deed. Then thereafter, what I had done is I had sold it to somebody else. And that somebody has sold it to the complainant. Now there is no problem whatsoever, my lords. The title of the complainant is absolutely perfect. My only concern, my lords, here was
That is if you enter into a settlement. Otherwise, we find that you entering into 2 agreements. One
No, my lords,
agreement and then a
my
sale.
first agreement, my
Is
lords,
not
was-
proper.
my lords, I fully
Which will
agree, my
require
lords.
interference.
Well,
If
my
you
lords,
enter into
it
a
is a tool.
settlement,
Sorry, my
if
lords.
you enter into a settlement, it's a different issue. Any settlement?
I will consult with my client and
We'll have it on 5th. 12. Learned at the request of learned counsel for respond number 2, relist on 12. If there's no settlement, we won't interfere, Mr. Joshua.
My lords, I would only say this, my lords. The main apprehension of the complainant was that.
We are not concerned with the apprehension.
Very well.
We are concerned with the actions of your client. If your client has entered into 2 agreements, which is a very
No, my lords,
common
my
thing in
agreement had lapsed. And after
have you
that, the
issued-
court has not even given him specific performance.
Mr. Joshua, don't rubbish it like that.
Yes, my lords.
Have you issued a notice terminating the agreement? Had you informed them that you had entered into an earlier agreement?
My lords, I had not sold it to him. I had sold it to another third party. That third party in turn had sold it to him.
Have you informed that third party
My
about
lords,
it?
I will just get those instructions also, my lords. And
Unless
if
you
required, I'll
place
place it.
that, then please go through it, because whether now it is sorted out or not, you had no business
Yes.
to do 2 transactions.
But I agree, my lords. It might not have been right without doing the necessary disclosures.
Learned counsel for the petitioner is directed to place on record any document to evidence that the petitioner had informed the vendor of the complainant about the agreement of sale entered into with Mr. Srinivas Murthy, termination of the said agreement before selling the property to the vendor of the complainant. Relist on 12th March.
Great.
An interim order.
Interim order, sir.
Earlier granted is extended till next year. And appears dismiss.
83. Vaishnavi S. Desai.
Same.
84.
84, please, my lords. I appear for the petitioner, my lords.
Hmm.
The first and the second accused, my lords, who are the owners of the spa, the proceedings insofar as they are concerned, my lords, has already been quashed. Apparently, when the order was passed by this honorable court, inadvertently, my lords, the word customers was mentioned. Therefore, this is pending for last 5 years. The petitioner before your lordships is a housekeeping manager, my lords, who is arraigned as accused number 3. Your housekeeping manager, this is a case registered under Immoral Traffic Prevention Act, my lords.
So 1 and 2 is been quashed.
To be honest, my lord, the entire proceedings has been quashed. 5 in the customers. So
Where is that order?
I have already placed it on record, my lords. There is an order passed.
Page number.
That is not part of the petition, my lords. I have placed on record 3 hard copies of the orders, my lord. Memo jote kottidini. 3-4 ಸತಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇರೋದು. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೆ.
4 ಸತಿ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಕಾಪಿ ಎಲ್ಲಿದೆ ಅಂತ.
I'll mention the criminal petition number, my lords. It's criminal petition number 7865 of 2018, my lords.
7865 of 2018.
Please, my lords. In this case, my lords, if I can request my lords to come to para 3, my lords. Learned advocate for the petitioner.
Those are customers.
That is what inadvertently it has been mentioned as customers, my lord. Apparently, they are the owners of this spa. On what count this case was quashed is the raid and the seizure, my lords. This precedes and later the FIR was registered. Only on that count, my lords, the entire proceedings has been quashed. First and second accused, my lord, wherein I have only appeared. That was quashed because of that one particular.
Without registering the FIR.
Please, my lords.
Without registering the FIR, it's investigation happened, therefore it's quashed. Against them also it led to quash. The entire FIR is quashed.
Entire proceedings itself is quashed, my lords, because
how can it continue against you?
Adenaಗಿದೆ first same order, my lords. If I may request your lordships to kindly come to the last paragraph, my lords.
We have read that para 5.
Para 5. Subsequently, also the entire proceedings. If your lordships are pleased to come to para 5, my lords. Hence, this petition merits consideration.
What survives in this petition, Trivikram, if it has been quashed?
Apparently, my lords, the state has been taking time, my lords, just to seek clarification. ಅವರಿಗೆ ಕಸ್ಟಮರ್ ಅಂತ ಬರೆದಿರೋದ್ರಿಂದ ಅವ್ರ ಕ್ಲಾರಿಫಿಕೇಶನ್ ತಗೋತೀನಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಏನ್ ಬರೆದಿರೋನು quashed ಆಗಿದೆ ಅಲ್ಲ, unless it is challenged. If the entire proceedings have been quashed. So we can't quash the same thing twice. That's our problem. Quash ಆಗಿರೋದು ಮತ್ತೆ quash ಮಾಡಕ್ಕಾಗಲ್ಲ.
But ಇವಾಗ ನಮ್ಗೆ ಏನು ಆಲ್ಟರ್ನೇಟಿವ್ ಇಲ್ಲ. ಕಸ್ಟಮರ್ಸ್ ಕ್ವಾಶ್ ಆಯ್ತು. The main owners, my lords of this spa, ಅವ್ರದ್ದು ಕ್ವಾಶ್ ಆಗಿದೆ. She is only the
We'll observe
housekeeping
that.
manager.
We'll observe that and dispose the petition.
Very well, my lords. Nothing survives for further
Petitioner
consideration.
is before this court seeking for the following reliefs. The proceedings in crime number 16 of 2017 have been quashed in its entirety in criminal petition number 7865 of 2018, while order dated 13 November 2018. Then the entire proceedings in crime number 16 of 2017 raised by Sadashinagar Police Station have been quashed. The question of it surviving against the petitioner alone would not arise. Hence, the relief sought for in the present petition have already been granted in WP in wide order date 17 November 2018 in criminal petition number 7865 of 2018. The petition, the present petition is disposed with the above observation.
I'm so grateful, my lords. Finally, it has reached its quietus, my lords, after 5 years.
Why are you keeping it when it is
The
being
state,
quashed?
every time when it was listed, I have argued the matter. It was adjourned only on the count that they would seek clarification. That apparently never happened. I'm so
Yes.
grateful.
88. Appeared thrice, dismissed.
90.
ಇವರೆಲ್ಲದ್ರು ನೀವು ಬೆಳಗ್ಗೆ ಇರ್ಲಿಲ್ಲ ಅವರಿದ್ರು. Mr. Ali. Ready na? Relist on 5th March. Interim order earlier granted is extended.
95. Satish there.
Appearing for the petitioners, my lords,
Yes,
kindly
madam.
give a short accommodation, my lords.
You don't appear in the matter, madam. We are thinking of dismissing. At the request of counsel for the, none appears for respond number 2, though called thrice. At the request of counsel for the petitioner, relist on 5th March, it is made clear that no further adjournment would be granted. If arguments are not advanced, petitioner will be liable to dismiss the non-possible.
Interim order may be kindly.
Interim order earlier granted is extended.
96. Are the dead parted?
ಯಾವ್ದ್ರಲ್ಲಿ ನೀವು? 96.
Engaged in this matter. Presently is arguing the matter in court on 23. Taken up.
ಬರೀ 3 ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅಷ್ಟೊಳಗೆ ಬರ್ತಾರಾ?
Try my best.
ಪಾಸ್ ಓವರ್ ಮಾಡೋದಾ ಏನ್ ಮಾಡೋದು?
Password ಮಾಡಿ. He is ready actually.
ಪಾಸ್ ಓವರ್.
97. Harish Kumar.
Finally, counsel is present. At the request of counsel for the petitioner released on 5th March, made clear that no further adjournment, dismissal. Interim order.
98. Shakuntala Shetty.
For thrice dismissed. ಮುಂದೆ. Yes. 88.
Mr. Mustaq Ahmad is not well.
Not well. 88 at the request of counsel for the petitioner relist on 20th dismissal ಮಾಡಿದ್ವಿ, relist on 20th March. Interim order ಇದೆಯಾ ನೋಡಿ, ಇದ್ರೆ extend ಮಾಡಿ. 94. 94 has been adjourned. ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ವಾ? Mr. Bhagwan is not well ಅಂತ ತಗೊಂಡ್ರು. Yes, madam.
My lord, serial number 83.
83.
3.
Dismissed.
Lords,
ಆಗೋಗಿದೆ.
I was held up in class.
ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ತಗೊಳ್ಳಿ. 83. ರೆಡಿನಾ?
Ready, my lords.
ಇಲ್ಲಿ ಪ್ರಮೋದ್ ಆರ್ ಇಲ್ಲ. Counsel for the petitioner is present, but none appears for respond number 2, though called thrice. If none appears for respond number 2 on the next date of hearing, petition will be taken up for consideration on the basis of submission made by counsel for the petitioner. Relist on 5th March.
My lord, there is a
And 5th March, please come here when it is called.
Please, my lord. My lord, there is a rectification that has to be made with regard to the interim order passed, my lord.
We'll consider that on that day.
My
Interim
lord, the
order.
interim order is already extended till the disposal of the petition.
Hmm.
However, the trial court.
Now, the latest Supreme Court guidelines are only till the next date. Nodidira?
Noted, my lords.
Extended till next date.
Grateful.
PPA gide. He's on his, we'll have it on 5th.
Please. Under Tuesday, madam.
And there are 96 of the request of counsel for the petitioner. You ready na?
Monday.
5th ready, 5th, 96.
Interim order. Interim order.
Interim order.
Serial number 86, madam. 5th March. 86.1 ಒಂದಿತ್ತು. ಜೊತೆಲೆಲ್ಲ ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ. ನಾನು ಎಷ್ಟು ನೋಡಿದೀನಿ ಅಂದ್ರೆ ಒಂದು 20 ಬಿಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ. ಉಳಿದೆಲ್ಲ ನೋಡಿದೀನಿ. ವ್ಯಾಲ್ಯೂವೇ ಇಲ್ಲ ಇದಕ್ಕೆ, ಮುಗಿದೋಗಿರ್ತಲ್ಲ, ಪರ್ಪಸ್ಫುಲ್ ಆಗಿರುತ್ತೆ. ಅದು ಬೆಳಿಗ್ಗೆ ಏನಾಗಿದೆ ನಮ್ಮ ಅಲ್ಲ, ನಾನು ಅಲ್ಲಿ ಜೋಡಿಸಿಟ್ಟಿರ್ತೀನಿ, ಸೀರೆ ನೋಡಿ ತಂದಿಡ್ಬೇಕಾದ್ರೆ ಮಿಕ್ಸಪ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ನನಗೆ ಇವತ್ತು ಹೊತ್ತು ತೆಲುಗು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎಲ್ಲಿ ತಂದಿರ್ತಾರೆ ಅಲ್ಲಿ ನೋಡಿ, ನಾವು ಕೈ ಲೈನ್ ನಾನೇ ಇಡ್ಸಿದೆವು ಬೇಡ, ಅವ್ನು ತಗೊಂಡು ಇಲ್ಲಿ ಇಟ್ಬಿಡ್ತಾನೆ. ಅದಕ್ಕೆ ನಾನು ಇವತ್ತು ಡಿಸೈಡ್ ಮಾಡಿದ್ದೆ, ಈಗ ಹೇಳೋದಲ್ಲ, ಒಂದು 20 ಪೈಲ್ದು ನಾನೇ ಕಟ್ಟಿಟ್ಬಿಡ್ಬೇಕು. ಅದಕ್ಕೆ ಅದು ಬಂಡಲ್ ಕಟ್ಟಿ ಇಲ್ಲ ಆಗ್ಬೇಕಾಗಿತ್ತು, ಆಗಿಲ್ಲ. ನಾನು ಇನ್ನೊಂದು ಸೈಡ್ ಮಾಡಿಲ್ಲ, ಈಗ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಹೈಕೋರ್ಟಲ್ಲೇ ನಾನು ರಿಟ್ ಟು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಫಸ್ಟ್ ಅಪೀಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಯಾವಾಗೋ ಒಂದ್ಸರಿ ಮಾಡ್ತಿದ್ವಿ, ಯಾರಪ್ಪ ಇದಕ್ಕೆ ಕೊಟ್ಟ ಆಯ್ತು, ಚಾನ್ಸ್ ಇದೆ ಅಂತ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಗೊತ್ತಾಗಲ್ಲ. ಇದಾದ್ರೆ ಏನಾದ್ರು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಓದೋದಕ್ಕೆ. ಎಲ್ಲ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ ಕಲಿ. ಯಾರೋ ನಾನು ಆಕ್ಚುಲಿ ಈ ಕೋರ್ಟ್ ಇಲ್ಲ, ಬೇಲ್ ಮ್ಯಾಟ್ರ್ ಸಿಗುತ್ತೆ, ಈ ಕೋರ್ಟ್ ಇಲ್ಲ ಅಂತ ನನಗೆ ಹೇಳಿದ್ರು. ಈಗೇನ್ ಮಾಡ್ತಾರೆ ಇನ್ನು ಮಂಡೆ ಟ್ಯೂಸ್ಡೇ ನಾನು ಬರ್ತೀನಿ ಇಲ್ಲ, ಇನ್ನು ನನಗೆ ಗ್ಯಾರಂಟಿ ಇಲ್ಲ. ಮಾಡ್ತಾ ಇದ್ದೀನಿ.